Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
Your Honor, this is Rafael Brewer, State Certified Court Interpreter. I have been previously sworn.
Okay, for your record, this is, the first name is, I'll spell it, S like in Sam, A-H like in Harry, A-M like in Mary, I-R like in Roger. Last name is Gumenez Solis, G-I-M-E-N-E-Z-S-O-L-I-S. That's probably hyphenated, but they, in the court record I'm looking at, is run together. And for your record, this case number 2022 M Mary Mary 6286 Alpha Orlando, O for Orlando.
Thank you, Your Honor. Your Honor,
Okay.
allow me just a moment to confirm the defendant can hear me through the headset.
Yes.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Okay, sir, you are arrested for a misdemeanor. It's a petty theft. And I do notice that you don't have any prior felonies or misdemeanors. This appears to be a first-time offense. And so, public defender, are we going to be pleading this or not?
There's no offer, Your Honor.
Okay. All right, sir, your bond is $500. That seems reasonable since you have no history that we're aware of. You are to not return to the place of this incident. You are not to contact the victim or witnesses. Your attorney is the person to do that. You are to remain drug-free, and you are prohibited from possessing any firearm, ammunition, or other type weapon. State, did I cover everything?
Your Honor.
All right, thank you very much, sir.
Sí, señor. Gracias.
Yes, thank you.
All right, and do we have another interpreter case? We do? Okay, so the next one, yes, we do have one more. I'm not sure about that. Is it one or? Just one. Just one more, okay. Okay, sir, are you James Houston? No, well, no, that's the wrong name.
Your Honor, the
Lopez,
interpreter
so
can confirm that this
No,
defendant can hear through the headsets, Your Honor.
Just a minute, I've got paperwork issue. Yeah, all right, some papers got stuck together. Okay, now I've got the right papers in front of me. Are you Virginia Lopez Soba?
Sí.
And,
Yes.
ma'am, you are arrested for a misdemeanor, a trespass on property after warning. Looking at your criminal history, there is none. There is 3 unknowns, but as far as felonies or misdemeanors that I'm aware of, there are none. Any offer from the state?
It is a withhold of adjudication, credit time served, and not to return, Your Honor, to 9370 Dearmont Avenue.
Okay. All right, public defender, is that acceptable?
It wasn't the one that was up there? Oh, just want to make sure. I'm trying to find her, Your Honor. Oh, there she is, sorry. She's Spanish, Your Honor, so I wasn't able to speak with her. So The offer from the state is a withhold of adjudication credit time served and no return to 9370, is it Dearmont Avenue. If you want to accept the state's offer here today to resolve the case.
Does she understand that if she accepts it, then
Wanna
she's
go
out
over?
of jail?
Mhm. And if you accept the state's offer here today, you won't have to post bond. The case will be resolved. You'll be released today.
Es que yo no tengo dónde vivir, porque lo que pasa
I
es que
have
yo
nowhere to
llevo
stay.
10 años viviendo en esa propiedad,
That's-
en casa de mi mamá.
So do you
I've
want
been
to?
living there for 10 years. It's my mother's house.
So do you want to resolve the case because the state's saying that you cannot return there? I believe they do not want you to return to the property.
Pero yo no tengo dónde ir, porque yo de Puerto Rico me enviaron para acá con un avión a casa de mi mamá, y entonces todos los beneficios con mi mamá me los dieron.
Well, I have nowhere else to stay. I was sent here from Puerto Rico on a plane to stay with my mom, and I have all my benefits there with my mom.
We can't solve that. That's not, we don't, our jail is not a motel. And so you have to leave. And so that,
Do you want to accept the offer? Or want to wait and resolve it later?
The bond.
Yep, there's a bond of, what, 500?
all right, we'll go ahead and
No, yo-
$500 bond and,
Oh, no, Your Honor, I was asking her if she wanted to just pay the bond or accept the offer. So do you want to pay the bond or do you want to,
Yo acepto la oferta o acepto el convenio, que me venga a buscar
I'll
entonces otra
accept the
persona de
agreement.
mi familia, porque yo entonces me voy con otra persona de mi familia.
So then I'll have to go with someone else in my family.
yes, yes.
she said she'll accept the offer.
Okay, we'll do a no contest.
¿Sí?
Because you don't have any history that we're aware of, we'll do a withhold in this instance. Time served, Madam, corrections is how much? 2 days. There's no, public defender, do you waive, or do you?
Yes, Your Honor.
All right, and then the court cost is $273. Given the circumstances, I'll reduce that to a judgment.
Thank you.
All right, thank you.
I just gave her the wrong name.
Okay,
You can take it. I'll give it to you in a second.
next should be Mr. Houston, James
Your Honor, the
Houston.
interpreter can respectfully request the case number for this last defendant, please.
Oh, yes, sorry, her name is Virginia, Virginia, Virginia
Oh, wait. Bring it back.
Lopez Soba, LOPEZSOBA. And the case number for your records is 2022 Mary 6287 Apple, Orlando.
And,
Thank you very much, Your Honor.
and Your Honor, one more thing. She is from Puerto Rico and her legal documents are at the house. So can she have a one-time return with law
Yes.
enforcement together?
Right, let's put in the documents that she does have you're still interpreting to her, right?
Yes, Your Honor.
Okay, I just didn't want to make sure, I didn't want to lose you. All right, you do have the right to call law enforcement to go with you to the house to get your documents, your clothing, your personal effects, and then to leave and don't go back. She doesn't want you to come back. And if you do come back, you're going to be arrested and back in jail. Do you understand?
Sí, pero ella también me dijo a mí que quería renta, que si yo le pagaba renta me podía quedar allí.
Yes, but she also wanted me to pay rent. She said I could stay there. if I paid
That's
her
more
rent.
information than I need. Take her away. Thank you.
Your Honor, does the court
James
require any
Houston.
further assistance from the interpreter?
Okay, Mr. Houston, first off, you're out on ROR, and so we'll go ahead and revoke that.
Your
And,
Honor,
yes, ma'am.
before we revoke, on the new case, the offer on the new law is an adjudication credit time served and no return to 707 Boston Avenue. And in exchange for accepting the state's offer, I would ask that you take no action on the out on bond.
So is the offer to resolve both cases?
Just the new law, Your Honor.
Just the new law case?
Mhm. And,
Uh,
go ahead.
State, are you okay with that?
Yes, Your Honor.
Okay. All right. In exchange for not revoking the ROR, the defendant has agreed to plea to the case that ends in 6275, loitering and prowling and resisting an officer without violence, misdemeanor. So he does have felonies and misdemeanors in his past, so we'll accept a no contest plea, and we do adjudicate to both counts. Time served on this case, the new case is how much?
2 days. 2 days, Your Honor.
2 days. Then the fine is, the court cost is $273. And sir, you are to pay the $273 within 30 days by either payment to the clerk of court or enter into a payment plan with the clerk. And if you do not do that, then your driver's license and motor vehicle registrations, if any, will be suspended until you do pay the money. All right, as far as the case that ends in 6275, that is sentenced and done with. The other case is still pending. Okay, next should be, oops, I'm sorry, Mr. Clerk, here. All right, next is, if you ever need me to slow down or stop or something, okay, don't hesitate, because it's important what you do, and I want to make sure that you're up with me. Okay. Okay, because sometimes I talk too fast. Okay, Joseph Luntz. Okay.
I will waive, Your Honor.
All right. We'll go ahead. Looking at situation. All right. I guess the $500 bond bail, is fine.
Yes.
And if he makes bail, he's not to return to the scene of the incident, not to contact victims or witnesses, to be drug-free, and to not possess any firearms, ammunition, or weapons. Okay, next should be Samantha Johnson.
Yes, Your Honor.
All right, Ms. Johnson, you're arrested for a misdemeanor, failure of defendant to appear. This is a new charge. Apparently, you obviously have a pending case. I do see the bail was set by the judge in that case at $2,000, and so therefore we'll respect that. And if you do post bail, you are to be drug-free, not possess any firearms, weapons, or ammunition. Thank you very much. Next is Roy Lamar.
Ray Lamar is mental health.
Okay, mental health. And can we set him over for Saturday?
Who was it, Your Honor?
This is Lamar, Roy Lamar, or
No.
Ray.
I will waive, Your Honor. He's incompetent, so I just ask that you, I believe there's a bond on the failure to appear. I ask that you just stay that.
Okay, all right, we'll leave the bail amount of $100 as is, and, next we have, Paul, Roodlove, Roodlove. All right, Mr. Roodlove, you're out on cash bond, so we'll escheat that bond. It's, and then in that case, which is, in that particular case, which ends in 297, we'll go ahead and make that new bond amount to be $500. Then you are now arrested again for robbery with armed with a deadly weapon, and that's number 1. Number 2, false imprisonment. Number 3, burglary of a structure with assault and battery. Number 4, battery. And the weapon is a small gun with a black and blue stripe, so it is a firearm. So that's the new charge. So, State, you want to talk to me about whether the count 1, I think that's a F1? Or is
That is an F1 punishable by life, Your Honor, as is count 3, burglary of a structure with assault or battery therein. That is also punishable by life. For those 2 offenses, I ask defendant be held no bond.
Okay. All right. Count 1 and count 3 are both no bond and remain so. And then count 2 is $150 and the battery is $100.
You said 150.
He's not going anywhere anyway, so.
Count 2.
And then 150.
If he, so, if he does get bond, they can then put the conditions. Okay, State, was there anything else I needed to do?
If you're not going to give conditions, Your Honor, no.
Right,
Oh,
all right, next,
Your Honor, can you
yes.
advise the defendant he has an immigration hold?
okay, sir, it is required by law that we notify the ICE people that you may be an illegal immigrant, and they will take whatever steps they're going to take. So understand, it's not just us, but ICE will have, you'll have to deal with ICE also. All right, thank you very much, sir. Okay, now, okay, these are arraignments? Okay, all right, I have an arraignment. So this is, let me see, Camillo Bannister.
yes, Your Honor.
Okay, Mr. Bannister, you are charged with 2 counts of battery. They're both misdemeanors, and we'll enter a plea of not guilty. I do appoint the public defender.
I will, I believe it's a VOP, Your Honor,
Oh, this is a VOP?
and I will enter a
Oh.
denial.
Yes, I now that you say that, I see the VOP. So there's no bond, and so you'll go to the VOP court within about 5 days and deal
They're
with.
going to give us a date, Your Honor.
Say again?
They're going to give us a date right now.
Okay.
Division 85, VOP status hearing October 6th, 9 a.m., courtroom 4A.
Oh, good. That's good that we have the date. All right, next we have McElwin. Okay, Rodney McElwin. Sir, this is a violation of conditional violation of pretrial condition.
And we're going to enter a denial, Your Honor.
Okay.
I mean, not a denial, we're going to enter a not guilty, sorry.
Are entered not guilty, and
Division 50, pretrial conference, October 21st, 9 a.m., courtroom 4E.
All right, that's your next court date.
okay. Next, we have Mr. Kane. So, Mr. Kane, you have been arrested for a misdemeanor. It's a petty theft with prior convictions. You have 3 felonies, 12 misdemeanors, and therefore we'll change your misdemeanor to be $1,500 instead of $500, based upon the fact that you do have a significant number of priors. That if you do post bail, then you are not to go back to the scene of this incident, not to contact the victim or witnesses. Your attorney will do that for you. And let me just look one more thing. Okay, and then you are not to possess any firearms, ammunition, or other weapons. Thank you very much.
Your Honor, there are 2 cases.
He does? Okay, let me separate these.
Yeah.
Okay, here's the second case. Okay, and then it's a petty theft also, a misdemeanor. And so we'll go ahead and set the bail at $1,500 and the same conditions. No return, no contact, no firearms, ammunition, weapons, and no drugs. Is there anything else from anybody? All right.
No, Your Honor.
Thank you very much.
You have more than one. I'm looking at it. Where are you? You have 2, you have 5.
Okay, next we have Cody, Randall Cody. Mr. Cody, you were arrested for a misdemeanor, trespassing in a structure or conveyance after warning. And you have 5 felonies, 26 misdemeanors. So your bail is...
There was an offer to resolve with an adjudication of guilt, 5 days in the Orange County Jail with credit for time served, and no return to 2257 East Cimarron Boulevard. Mr. Cody would like to accept an interplea of no contest.
All right. The court accepts... Oh, I'm sorry.
He has 2 days, Your Honor.
Yes.
You have to do 3 more days. No, he has to do 3 more days. Because he just violated right here.
Yeah, these papers are on some other cases. Okay, we do accept your no contest plea. We do adjudicate the time served. Did you say that was
2 days, Your Honor.
2 days? Okay. Your court costs are $273. You are to go to one of the courthouses, pay that amount of money, or enter into a payment plan within 30 days. If you fail to do that, then driver's license and motor vehicle registrations, if any, will be suspended until you pay. All right, thank you very much.
Your Honor, you did know that it's 5 days Orange County Jail as opposed to a credit time served offer.
But he has 5 days with credit for 2, so he'll do 3 more days.
Oh, okay, I'm sorry. So it's 5 days, the sentence is 5 days with 3 days credit for time?
2 days.
2 days credit for time served. So he has 3 days to serve.
Yes, Your Honor.
Your Honor, Delbert Henry's behavior.
Your Honor, could we reset for tomorrow? There's an offer to resolve his case.
Okay. We'll bring him back tomorrow. Okay, now, well, did I give, well, this says Parks, and then this says Mercier. Okay. All right, next we have Lorenzo Parks.
No, this is him.
Mr. Parks? Okay, all right, Mr. Parks, you're arrested for a misdemeanor. It's a battery, and you have 9 prior felonies, 17 misdemeanors, 8 failures to appear, and so we'll change your bail to be $2,500. And if you make bail, then you are not to return to the scene of this incident. Do not contact the alleged victim, witnesses. Your attorney can do that. You are to remain drug-free and to not possess any firearms, ammunition, or weapons. Thank you very much.
Your Honor, could he have a one-time return with law enforcement? He did live there with the victim.
Okay, thank you for that information. You can go there, but first you call law enforcement. They will go with you to get your stuff, clothing, anything you need for work, that sort of thing. It's a one-time return. Thank you very much.
Skip over Mr. Davidson Mercier. He needs a Creole interpreter.
I apologize, but I didn't understand you.
We skip over Mr. Davidson Mercier. He needs a Creole interpreter.
Oh, okay, needs a Creole interpreter. All right, we will skip over him. Let me know when he's available. Let me know when the interpreter is available. Okay, this is, next is Julio Acosta Diaz. Okay, sir, you're released on ROR, and in that case ends in 787, and you're also released ROR in a case that ends in 785, and then you're also on a surety bond in a case that ends in 783, and now you have a new case, but we'll get to that. So we'll start at the beginning. So the first case that ends in 787, we revoke the ROR, and this is looking at the nature of the crime. Are there several counts? I don't know. I have that information. It looks like 1, 2, 3, 4, maybe 4 counts.
Yes, Your Honor.
Okay. So the possession of fentanyl, we'll go ahead and let me look at.
And Your Honor, I would note that he was arrested back in June, looks like June 12th. He was seen. To date, no formal charges have been filed on his 2022 CF678780 and 2022 CF678580. the state has not filed charges, which is why he was released ROR. So given that, I would ask that you take no action on those two cases.
Well, it's not an unreasonable request. State, are you going to do anything?
I'm sure we will eventually, Your Honor, but defense is correct. As of today's date, no formal charges have been filed. However, with regard to the dwellers, 22 CT 4783, formal charges have been filed in that case, and an arraignment is set for September 27th.
Okay, so at the request of the public defender, the two ROR cases, I won't revoke those because of for the reasons stated. In the case that ends in 783, which is habitual driving while license suspended or revoked, the $2,500 bond is revoked, and that is changed to be a $3,000 bond. And then the pending new case, trafficking in fentanyl again, resisting an officer and carrying a concealed weapon. Let me look at that. State, the weapon, can you find it quickly?
It's a BB gun, Your Honor.
It's a BB gun? Okay, all right. A BB gun is not a gun. It's in that sense that you and I are concerned about. All right, so we'll go ahead and the first, on count one, it has $100,000. We'll leave that as is. Resisting an officer without violence is $100, and carrying a concealed weapon, $150. And then if you make bail, you are not to contact the victim or witnesses. Your attorney is to do that. You are not to return to the scene of the incident, and you are not to possess any weapons, firearms, ammunition. All right, thank you very much.
This one?
Mm-hmm.
Isn't this the one where they refund? No.
Do I need to do anything?
It says recall.
What close, what case number?
The warrant, this charge is, it's honestly a warrant. That's only indication of.
Okay, do we have a Creole interpreter?
Yes, Judge. Thank you for calling Language Line Solutions. This is Nadej, ID 366712, and I'll be your Haitian Creole interpreter today.
Okay, thank you. If you could turn up your volume, because it's very faint on our end. So if you could control volume, that would be good. Okay, so for your information, I know you need the name and also case number. So the name is Davidson, D-A-V-I-D-S-O-N. That's a first name. Davidson Mercier, I will spell it M-E-R-I-S-I-E-R. And the case number is 22MO1052 Alpha, Orlando. Okay, and if you will tell him that, let me just get the paperwork. Okay, if you tell him that he's been arrested for an ordinance violation of possession and consumption of alcohol in public.
Monsieur, moi so haïtien corps interpréteur, jodi yo arrêté à cause de ordonnance violation alcool en public.
And Your Honor, he does qualify for pretrial release. I would ask for pretrial release in this case, given I don't see any history.
Ou qualifié pour avant jugement lagué, nous pas ouais ça dans cas.
All right, I notice that he does not have any felonies or misdemeanors or failures to appear. So there's, from a record standpoint, he has no prior history. So does he qualify for pretrial release? Are we all in agreement?
Yes.
Pretrial
No.
release?
Yes. Yes.
Yes, okay. All right. Sir, we'll go, you have two options. I can release you and the case can still be pending, or we could plea it out today. This type of case, I think, is fairly, we should take care of it today if possible. But State, do you agree?
Your Honor, an offer was relayed. It is a withhold of adjudication and credit time served.
All right, and so, sir, we can, if you plead today, it'll be a withhold of adjudication since you have no priors, and no contest plea, which neither admits or denies. There is a court cost of $273 that I want you to pay, but you can enter into a payment plan and pay that over a number of months. Do you want to take care of this today, or do you want to go, or do you want to just be released on bail?
Your Honor, given he has, I don't see anything on his record. The city may give him what they call pretrial diversion, so that it doesn't go on his record. That's what I'm thinking about, keeping his record clear.
Okay.
Which is why I just asked for pretrial release.
Okay, all right, we'll go ahead and do the pretrial release.
And Your Honor, the interpreter has to interpret.
Okay, go ahead, yes.
Judge, this is the interpreter. Do you want me to translate everything that just discussed, or what I'm not sure. How do you want me to proceed with this?
Yes, so just tell him, I think at this point, we're going to release him on pretrial release, and he is to stay in contact with his attorney. All right, thank you. That's all you need to tell him.
N'a plagué ou na avant jugement, et puis pour être en contact avec avocat.
So, can you tell him he will be released today without having to post a bond? I did circle the attorney's telephone number for him to stay in contact with them on the green form.
Ou plagué jodia, et ou pas gen pour payer aucun liberté provision. Et puis, gen numéro avocat nous font on a donné pour contacter yo.
Where is, I made a mistake again. Step together. Thank you.
Merci. Is there anything else, Judge?
No, that's fine. Thank you very much.
You're welcome, Judge. Thank you for using our services. Have a good day.
Yeah, this, so I have, did I do that? Oh, I did it, okay. Okay, all right, next is Romilo Eugene Alexander.
Yes, sir.
Okay, Mr. Alexander, you are charged with a felony, the sale and delivery of cocaine. And I do see that you were arrested on a warrant, and that the judge that reviewed that gave you a $7,500 bond, or bail, I mean. Yeah, you know, bond is the insurance company's contract. Bail is what we really do. And so I always, so bail is what, $7,500 bail. So we have to respect that. And so I see charges.
This was just an add-on charge, Your Honor.
Just an add-on, okay. All right. So the is $7,500. You are not to return to the place of the incident, and no contact with any victims, co-defendants, witnesses, and no drugs, and no possession of firearms, ammunition, or weapons. Thank you. There you go. Sorry.
Your Honor, Terrell Battle refused.
Okay.
And I will waive, Your Honor.
Okay, so Mr. Battle he's waiving appearance. It's a no bond. We'll leave it as is. And,
He's entitled to. Your Honor, he's entitled to a bond.
okay, all right. State recommendation?
Your Honor, I would ask for at least $5,000, considering that Mr. Battle's last conviction was for a bat Leo back in June, and he also has a conviction for indecent exposure, ×2, Your Honor. He is now on probation.
Defense has no objection, Your Honor.
How much did you say?
At least $5,000, Your Honor.
I'm sorry, I can't quite hear.
At least $5,000?
5,000, all right. All right, $5,000 bond, and the no return, no contact with the victim or witnesses, and no firearms, ammunition, or weapons. Anything else, State?
No, Your Honor, but there is a second offense.
There's what?
There is a second offense. There's a second case, 22 MM 6292.
Let me find it, because okay, I found it. Possession of drug paraphernalia, and we'll go ahead and change that $500 to be $1,500 because of his history. With the same conditions, please. All right. Anything else from the state?
No, Your Honor.
Thank you. I'm not sure where it goes. Okay, next, Daniel Benchamal. Beachamal?
It's Benchamal, Your Honor.
Benchamal, okay. Sir, you're out on a surety bond, and for battery on a law enforcement officer, possession of fentanyl, criminal mischief, open carry on open carry, I guess. What's an FA?
Firearm.
Oh, okay. All right.
Your Honor, he has a private attorney on the out on bond, but he was in pretrial diversion on the out on bond, given I'm assuming he had no history. So I just ask that you consider that, but not to appoint us on the out on bond because he already has an attorney.
All right. We'll revoke the prior surety bond in case that ends in 1480, and the battery on a law enforcement officer would be $2,500. Possession of fentanyl, state recommendation.
Your Honor, the prior bonds appear to be $2,500 for the Bat Leo. The possession of drug paraphernalia and the open display of a firearm was both $100, and the criminal mischief was $150. I would recommend that you revoke and double, Your Honor.
All right. Okay, the open carry of a firearm, that bond, the new bond is $20,000. Criminal mischief is $1,000. Fentanyl is $10,000, and battery on a law enforcement officer is $5,000. And then the new case, possession of cocaine, we'll go ahead and do $5,000. Possession of drug paraphernalia, $1,000. Sir, you are not to contact on all of those cases. No contact with the victim, no return to the premises. Do not carry any firearms, weapons, or ammunition. Anything else, State?
I apologize, Your Honor. With regard to the out on bond, can you give us those bond amounts again, please?
Okay, did you jot them down? Oh, sorry. All right, starting at the bottom, the carrying of firearm is $20,000. Then criminal mischief, the criminal mischief, I think, was $1,000, and then possession of fentanyl was $5,000.
You see?
Say again?
I don't know.
$10,000, okay. And battery on a law enforcement officer, that was $5,000. Yeah, that was $5,000.
Thank you, Your Honor. And he also has a no valid driver's license case, 22 CT 5245.
Okay, let me find it.
A second.
Oh, no valid driver's license. Okay, I found it. So we'll go ahead and leave it as is. The $500.
And Your Honor, as far as the out on bond open carry, the original bond they had was $100. He had no convictions. He was actually in pretrial diversion for that case. I would ask that you, if you're gonna I would ask that you not set it at $20,000, given that it was originally at $100. The state asked for you to double that bond, but I would just ask for at least a $5,000 bond there. A $20,000 bond is tantamount to no bond. He can't afford that, and a $10,000 bond. He didn't pick up another open carry of a firearm, so I just ask that you consider those factors.
No, I think carrying a firearm, no. And so the answer is no. And so it stays like it is. Okay, next is Teresa Behrens. Okay, Ms. Behrens, you were arrested for a felony burglary of an unoccupied dwelling, unarmed.
And Your Honor, I would argue no PCS to the burglary of a dwelling. There was no crime within. It's merely a trespass, so I just ask that you find PC only for the trespass.
Okay, State, your thoughts?
I agree, Your Honor. The statute for a trespass is 810.09-5.
Okay, and so I think, so the public defender is saying it's a trespass, not a burglary.
That is correct, Your Honor. There is no crime therein.
Okay, all right. So I do, what, do you need time to amend or?
No, Your Honor. No, Your Honor. The state and defense are in agreement that based on the facts asserted, it is only a trespass.
Right. And so, all right, so we'll go ahead and look at, she has 4 felonies and a misdemeanor.
You do?
So we'll leave the,
Yeah.
we'll change the,
Okay.
right, that 5,000 is too high for that.
Yes, Your Honor.
So we'll put it down. Since she's
But you
been in the system before,
do not,
we'll do it at 2,000. And
don't qualify.
so 2,000 is the money, and no contact, no return, and no weapons, firearms or ammunition.
I hear what
All
you're
right,
saying. I'm
state
telling you,
anything
you
else?
don't qualify.
No, Your Honor.
Okay, you want a one-time return? Your Honor, and can she have a one-time return with law enforcement? She left her items there.
Yes.
Okay, so you can go back once. Yeah, it's 300 with the bail bondsman. Wait, stop. Your Honor, she can't afford 2,500. Would you consider $1,000 bond given that it's only a trespass? She was was it evicted or something?
All right, any objection?
No, Your Honor.
All right, we'll change it to 1,000.
You're welcome.
All right, Christopher Bivens. All right, Mr. Bivens, you're charged with a felony, grand theft, 3rd degree. And looks like you have 2 prior felonies, 2 misdemeanors, 2 failures to appear. So it looks like in every case you've ever been charged, you've failed to appear, because everything is 2. So we'll go ahead and change your grand theft to be $10,000, and that's primarily because you failed to appear in every case so far. At least that's what it looks like. So it's $10,000, no return, no contact, no firearms, ammunition, or weapons. Okay, let's see, Connolly Sergio. Okay, Connolly is the last name, okay, so it's Sergio Connolly. Corrections, are you okay?
Yes, sir.
Okay. All right, Mr. Connolly, first off, you're out on bond already for possession of cocaine. We'll revoke that bond, and then we'll make it $3,000. And then you have trafficking in cocaine. You have 6 felonies, 4 misdemeanors, 9 failures to appear.
He's not going to do.
And so the trafficking in cocaine is already at $50,000, and we'll leave it at that. So the $50,000 is the bail amount, and you are to not return to the scene of the incident, no contact with the victim or witnesses. Your attorney does that, and no firearms, ammunition, firearms, ammunition, or weapons. Thank you very much.
Wait a minute. Your Honor, I missed it. The out on bond, did you revoke?
Yes.
I would ask that you not. He was arrested back in May. The state has not filed any charges. It's May 11th, it looks like.
That is correct, Your Honor.
And we're in September.
Okay. All right. We'll go ahead and not revoke that bond since the state hasn't filed on it in what appears to be a reasonable time. But I think a lot of that is getting back from the laboratory, isn't it?
That is correct, Your Honor.
Yeah, so the delay is, in all these drug cases, is that the state of Florida doesn't have sufficient analysis. So people sit in jail when there's no evidence against them as far as what it is.
Yes, Your
And
Honor.
so I think, you know, I agree with you that it's ridiculous.
Yes, Your Honor.
It's the same thing as DNA. It makes me so crazy that most of the DNA that sits in the files are not analyzed.
Yes, Your Honor.
So anyway,
You got a $50,000. That's it.
okay.
No.
Okay, next should be Shannon Davis.
You left it alone.
All right, Ms. Davis, you arrested for a felony, criminal mischief. I don't see any criminal background, so this appears on the computer to be a first-time offense. And so,
Your Honor, she does qualify for pretrial release. I would ask for pretrial release.
okay, state any objection?
No objection, Your Honor.
All right, pretrial release, and the criminal mischief, do not return to the scene of wherever that is. Don't contact anybody, no victims, witnesses. Your attorney will do that. And you are not to possess any firearms, ammunition, or weapons. Anything else, State?
No, Your Honor.
Thank you. Okay, Philip, go lightly. Yes, sir. All right, sir, you're charged with a felony, a burglary of a structure, and a petty theft. And, okay, and so looking at you have 2 prior felonies, but you have 11 misdemeanors, 1 failure to appear. So the burglary of a structure, we'll change that to be 5,000, and the petty theft, we'll leave it 1,000. And so that's your bail. Do not come back. Do not return to the scene of these incidents. Do not contact anybody. Your attorney will do that. No firearms, ammunition, or weapons. Thank you.
Your Honor.
Yes, sir.
I wanted to plead. I know, please, I understand. I have some medical issues. I was trying to get an ROR.
Okay, that's,
This came up in 2020.
no, tell your attorney, and your attorney can then take whatever appropriate action is necessary. Thank you very much. Next, we have Dennis Griffin. Okay, Mr. Griffin. You're arrested for a felony, workers' compensation fraud, and a grand theft 2nd degree. And then looking at your history, you don't have anything in Florida or that came up. It's just a couple of unknowns. So
He does qualify for pretrial release, Your Honor. He's on Social Security disability.
okay,
I
all
would
right.
ask for
Pretrial,
pretrial release.
since you do qualify and there's no history, you can do pretrial release. So which means you'll be released on your signature that you promised to come to show up in court. And so no contact with the victims or witnesses, no return to the scene of any incident that may be described in the affidavit, and no firearms, ammunition, or weapons, okay?
Yes, sir.
All right, thank you very much.
Release.
Okay, next we have Cody Hemphill.
Yes, sir.
Okay, all right, sir, you were arrested for a felony, a burglary of a conveyance, trespassing in a structure or conveyance, possession of burglary tools, resisting an officer without violence. You have 5 felonies, 4 misdemeanors, 6 failures to appear. So the burglary of a conveyance will change that to be $10,000. Trespass in a structure will change that to be $1,000. Possession of burglary tools, another $1,000. Resisting an officer without violence, $500. Do not return to the scene of any incident described in the affidavit. Do not contact any co-defendants or witnesses. Your attorney will do that. Do not possess any firearms, ammunition, or weapons. Thank you. Okay, next should be Kenneth Jean. All right, Mr. Jean, you've been arrested for a felony, a burglary of a conveyance, So there's two charges. And you have no felonies, but 1 misdemeanor and no failures to appear. So the all right. We'll go ahead and leave the bail at $3,500 for the first one and $150 at the second one. And then, so no return to the scene, no contact with victims, co-defendants, witnesses, and no firearms, ammunition, or weapons. Thank you very much.
Thank you, sir.
That's what I thought.
Your Honor, yeah, that's what I thought. Your Honor, just a second. I just wanted to make sure I was rereading it. This is the same as the last case, for the burglary of a conveyance. I don't see any crime within. He notes that he got into the truck for shelter. Without any other crime, it would be a mere trespass. Is that your understanding? Because I don't see anything.
Well, he trespassed on the property. He trespassed on the property and then he got in the vehicle.
So that's the crime.
Yeah.
Okay.
With regard to that one.
Okay,
I'm
I'll
sorry.
leave it. I didn't know. I just was thinking. Stop talking about the facts, please, please. Thank you, Your Honor.
Okay.
We agree it's enough for PC.
Okey-doke.
He stated-
All right, now, next should be Kevin King. Mr. King, okay, good. All right, Mr. King.
It was a weird one.
I noticed that everything is no bond. Is there a reason?
Your Honor, for some of them, for the first, I will say 3, the trafficking offenses with a weapon, those are PBLs. So at your discretion, you could hold a defendant at no bond. However, if you were to look at the bond schedule, amounts are given. So it's at your discretion as to whether or not to give a bond. The rest of them, defendant is entitled to a bond.
Okay, so we have trafficking in cocaine
Yeah.
or with a weapon, and then that weapon being a firearm, which is also charged later.
I apologize, Your Honor, and it was just brought to my attention that count 2 does not have a weapon. So he is entitled to a bond on count 2. So it is only counts 1 and 3 that because they are trafficking with weapons, those are the punishable by life offenses.
Okay, if they're punishable by life, but they're still entitled to a bond, a bail?
No, Your Honor, what I'm saying is they are punishable by life, but the bond schedule does list an amount. So you can either go by the bond schedule or you can use your discretion and hold defendant at no bond.
Yeah, I think because the public defender can always file a motion for a bond, and they can look at the facts better than we can. And so we'll do no bond on the count one. On count two, we'll do 50,000.
Your Honor, only because there is a bond schedule amount to be used as a guidance for count two, because it is fentanyl and it is over 14 grams, the bond schedule indicates that it would be 400,000.
400,000?
Yes,
Okay,
Your Honor.
thank you.
Actually, I apologize.
Oh, no,
That is because it was with a weapon, but there is no weapon listed for count two, so it's actually 200,000. I apologize,
so
Your Honor.
no. We're all trying to read these things quickly and do our best. So 200,000, you said?
Yes, Your Honor, for
All
count
right,
two.
then count three is no bond because it's not entitled to a bond at this point. That can be decided later. And then possession of cocaine with intent to sell with firearm. What is the bond schedule on that?
From what I saw, Your Honor, it was 15,000.
15,000, so we'll do 20,000. The possession of fentanyl would do it 10,000. Possession of meth, 10,000. Possession of weapon in commission of a felony would be 20,000. Possession of a firearm by a convicted felon would do 50,000. And then no return to the scene.
Your Honor, there are three other offenses,
Oh, there are.
counts 9, 10, and 11.
All right, let me turn the page. Okay, got it. Possession of ammo by convicted felon, we'll do that at 20,000. Possession of cannabis with intent to sell at 5,000. Manufacture a controlled substance, we'll do it 20,000. And so no return to the scene, no contact with co-defendants or victims, no firearms, ammunition, or weapons.
Your Honor, if I may, I would also ask that the defendant comply with Florida statute 903.046, sub 2, sub 4, and that is with regard to verifying the source of any bond amounts.
Right. So before you spend money on a bail bond, you need to run it by your attorney, and then you may have to have a hearing to check the source of the money. In other words, you can't use criminal money that's gotten from criminal activity to be able to pay for a bail bond. That's prohibited by law. So you would have to. So your attorney is very competent. Public defenders are good lawyers, and so I'm just saying, before you spend your money, you better check it. And so do put in the order that he is prohibited from posting bond until he complies with
Florida statute 903.046, sub 2, sub F.
Okay, you got it.
Your Honor, if I could also ask for a defendant to surrender his passport. He has previous convictions for trafficking in cocaine.
Did you want me to?
Ask him to surrender his passport prior to being released, Your Honor.
Okay. How about if does he have a passport?
I do not know, Your Honor.
They didn't know, Your Honor.
Okay, but so it seems like we should be able to check that out of curiosity. Okay, so put in there that if he has a passport.
Yes, Your Honor.
It's an if thing. If he has a passport, that he has to surrender it.
Will that work?
Within 7 days. So
7 days.
so that gives you time to get out of here and gather wherever it may be and turn it in. But it's.
And we're going to have the Arthur hearing, Your Honor, to deal with the proving the source of the funds and
Right.
setting the bond. So
Right. And
Thank you.
at that time. Okay, so are we done with that?
I think so, Your
Okay,
Honor.
Yes, Your
thank you,
Honor.
folks. Next, we have Morgan Marinello. Okay, and you are out on, oh, it says just open case. So there's nothing really for me to revoke, is there?
The grand theft motor vehicle.
No, he's saying
Okay, it
it's
says-
saying open case, so he didn't know she was.
There's an open case,
Oh,
but it's the one that ends in 297. So I don't, there's no bail or nothing to revoke. I think this is for information.
What is that, 2022? It's open. Let's see.
it appears that there was a bond of $3,500, Your Honor.
Oh, okay. So, and that's the case that ends in 297?
Yes, Your Honor.
Mhm.
All right. So the $3,500 bond is revoked and changed to be $10,000. And then she has a trafficking in fentanyl. 100,000 is what is the bond schedule apparently, and then possession of meth it has as 1,000. And so looking, she has 6 felonies, 3 misdemeanors, 3 failures to appear. With the 3 failures to appear, not that it's going to matter a lot, but the possession of the meth, let's just change that from 1,000 to be 10,000. But with all the rest of it,
It's already at 100,000 for the fentanyl. I just ask that you stay the 1,000. Usually they treat some of the charges as subsidiaries, and that's the lesser, and you already set 1,000.
okay, all right, that's fine. That's fine. So we'll just leave it as is. All right, no contact, no return, no weapons, firearms, ammunition.
Yeah, she was still talking. You heard him? Mm-hmm.
Okay, Terry McFadden. No, I'm sorry, wrong. I must be stuck in there. I hate that. Let me be more careful. Okay, let's see. Okay, Timothy Mattel. All right, Mr. Mattel, you're arrested for a felony. And the first one is a no bond situation. And then we'll leave the, it looks like you have 1 failure to appear. So I don't understand how you can have no felonies and no misdemeanors, but 1 failure to appear. But, so we'll leave that as is, because the first one is no bond, correct?
Your Honor,
Say
he's entitled to a bond.
he is for the first one.
Yes, Your Honor. It's a first-degree felony, but it's level 9, so he is entitled.
And what is the recommended bail?
To be completely honest, I'd ask for 100,000.
Okay, all right. We'll set it at 100,000, and then we'll leave count 2 as is, 5,000. Okay, then no contact, no return, no weapons, ammunition, firearms type thing.
Your Honor, I'd also ask that he have supervised contact with any minors.
Right, and no contact with any minors. And maintain separate residence with the victim. Okay, yeah, no contact, separate residence. Okay, Terry McFadden. Really? Okay, Mr. McFadden, you're out on bond already. The bond amount it shows is $5,100. So so we'll revoke that bond and burglary of a structure. So burglary of a structure would do a 10,000. I do see you have 5 felonies, 3 misdemeanors, 2 failures to appear. So burglary of a structure would do a 10,000. Burglary of a conveyance times 3. State, what does times 3 mean?
That he has 3 of those offenses, Your Honor.
In that one case?
Yes, Your Honor, he has.
Okay, no, there's 3 counts.
Yes.
Okay, I'm with you. All right, so count 1 of the case that ends in 407, it looks like. We've got that as 10,000. Burglary of a conveyance, so we'll go ahead and do that at 5,000, 5,000, and 5,000. And then there's a grand theft 3rd degree 3 times. And so we'll make that 2,500, 2,500, 2,500. And then there's a criminal mischief. Times 3. Okay, and so that'll be 1,000, 1,000, and 1,000. And then there's a criminal mischief again, apparently. And there's no multiplier and so we'll do that at 1,000. And so that takes care of what he's out on bond for. Now he's back again. And so in this new case, burglary of a structure, we'll go ahead and make that $20,000. Grand theft 3rd degree, 10,000, and criminal mischief, 1,000. You're to have no contact with the victim, no return to the scene, and no firearms, ammunition, or weapons. Thank you. Okay, next would be Amber Register. Ms. Register, you're out on bail. And is possession of fentanyl, possession of meth, possession of cannabis.
Your Honor, I would ask that you take no action. She was arrested July 23rd, and to date, no information has been filed. So I just would ask that you take no action on the 2022 CF 854280. And information has been filed on the driving while license suspended.
Okay, which one did you say the information's been filed?
The driving while license suspended, 3rd.
The driving, okay,
Yes,
I got it. All right, so the case that ends in 542, we'll leave as is. And then the driving while license suspended, we'll revoke that bond and change it to be 5,000. And then possession of fentanyl, so we'll go ahead and looks like she has 2 felonies, 6 misdemeanors, no failures to appear. So we'll go ahead and the fentanyl, we'll go ahead and do that at 10,000. The meth at 5, and then the paraphernalia at 1,000.
Oh, so that was 5,000 on count 2?
5,000, yeah, 5,000. Yeah, when I do that, please always correct me, because I'm thinking 5,000, but I say 5, so I meant 5,000, thank you. Okay, then,
Oh, wait, no, 5,000 on.
no return to the scene, no contact, no firearms, ammunition, or weapons.
Your Honor, she has a second case.
Say again?
She has a second case, Your Honor, 22 CF 10726. It's another dwellers.
Okay, I found it. Okay, this is driving while license suspended or revoked, the $2,500 bond. We'll leave it as is.
You can bond out and just hold over.
Next would be John Roberts. John Roberts.
Yes, sir. Junior, John Henry Roberts Jr.
Okay, Mr. Roberts, you are arrested for a felony, a petty theft. It's a felon, even though it's a petty theft, because you have prior petty thefts, it is now graduated to be a felony. Apparently, whoa, goodness gracious, you're a frequent flyer. Have you been to prison yet?
No, sir.
Okay. I notice you have 28 felonies, 8 misdemeanors, 1 failure to appear, and robbery, petty theft, grand theft, resisting a merchant. All right. So we'll change the
And it's on the grand theft?
bail from 1,000 to be 10,000, and you're to have no contact with the victim, no return to the scene, no drugs, no firearms, ammunition, or weapons.
And Your Honor, this was just it was an add-on charge. It was set at 1,000, but could you do 5,000 since it's an add-on? It's not, they just added a new charge based on other facts.
Yeah, no, with that much history, 28 felonies. The reason
No
I
problem,
wasn't
sir.
being disrespectful when I asked him if he'd been to prison, I would have assumed somewhere in there it would have been prison.
He said he's shocked you haven't been to prison. So I will let him know that.
Okay, okay, next is Eddie Rodriguez. Okay, Mr. Rodriguez, you're arrested for a felony, a failure of defendant to appear in an underlying case, and you
I believe it's set at no bond, Your Honor.
right. So, state, I would normally do like a $2,500 bond.
No, Your Honor, because it's an FTA on a felony, you leave it at no bond.
Oh, okay, and just let the trial judge do it?
Yes, Your Honor.
All right, we'll leave it alone, and you will see the trial judge who will deal with it. All right, thank you. Next, so Amos Silverrain. Okay, Mr. Silverrain, you're arrested for a felony, possession of cocaine, and okay. All right, looking at your history, you have Florida arrest, Okay, in other words, there was an arrest, but you were never charged with all, is that,
That's correct, Your Honor. It looks like he only has a petty theft conviction in 2020.
okay. All right, then, all right, we'll leave it as is then. And so, no return to the scene of the incident that's described in the affidavit of arrest, no contact with the victim or co-defendants, no weapons, ammunition, or firearms. Thank you very much.
Your Honor, can we also have random urinalysis?
All right, let's have, let's go ahead and have him drug tested 30 days from now and each month until the case is disposed of. And if you turn up positive, you're going to be right, they're going to arrest you, you'll be right back in jail. So it's your choice. Thank you very much. Next is Wall.
Keep your mask on. Keep your mask on.
Christina Wall.
Hello.
Okay, you have a failure to defendant to appear. And that's a felony, so the judge in that case should handle it?
Yes, Your Honor.
So is the rule that you're aware of, is if it's a felony, just let the trial judge do it? If it's a misdemeanor, we can do it
No, Your Honor, regardless,
regardless?
if it's an FTA, it should be left for the trial court.
Okay, good. All right. Thank you for that information. Okay, we have one more. This is Marisa Dougherty.
And Your Honor, I'm sorry, on the prior case, could you not appoint us? It looks like we were withdrawn because of a conflict, so I don't want us to be appointed.
Okay, make sure you, in the paperwork. All right,
Wall, Christina.
all right, done.
Thank you.
Okay, now Dougherty. You're going to have to speak up. I think you're going to have to increase your volume because I can barely hear you. Are you there?
I am here. Can you hear me now?
Okay, we are getting the defendant. Now, the defendant, for your purposes, is Ruth Rodriguez, R-O-D-R. Okay, Rodriguez, R-O-D-R-I-G-U-E-S. The first name is Ruth, and the case number is 2022 MM, that's Michael, 6294, A like an apple, and O, which is orange. Okay, do you need any other information?
No, I don't. Thank you so much.
All right, thank you. All right, and tell the defendant that she has been arrested for a misdemeanor, which is a domestic violence battery.
Então a senhora foi presa, né, por uma ofensa pequena, que foi violência doméstica.
Sim, estou muito arrependida por isso.
Yes, I'm very regretful for that.
Okay, now, is there anyone in the audience, and let me just speak to the audience for a moment. There's several people out there. So when we call the case, I want you to stand up and make sure that I see you, because if you've made the effort to come here, we want to be respectful and to have you come into the witness box and to tell us whatever you feel is important. And so if there's anybody here for this particular case, please stand up. There is nobody. And so we'll go ahead and then, what's that do with my, State, is there anything that normally we would say that she cannot return, all of that? Do you have any information that would change that?
No, Your Honor.
Okay. All right, ma'am, since there's nobody here to talk, to give us additional information, the standard routine is that you cannot go back to that house. You must live separate. You have to find a different place to live temporarily, and you're not to have contact with the victim or witnesses. And so, do you understand that?
Então tá, então como não tem ninguém aqui para falar, para ser testemunha, né? Geralmente nesses casos o que acontece é você não pode voltar para o lugar onde isso aconteceu e não pode ter contato com a pessoa que isso aconteceu. A senhora entende isso?
Sim.
Yes.
All right, and from looking at her background, she has no criminal activity, and she does express remorse, and so she would qualify for pretrial release? I'm sorry, I can't quite hear.
No, she doesn't qualify for pretrial release due to her legal status in the United States.
Okay. All right, we'll go ahead and give you a $500 bond. Your bail is $500. So post that bail and obey those requirements. And as far as I know, that's the end. Is it correct, State?
Yes, Your Honor.
Okay, thank you very much.
Your Honor, did you give her a one-time return with law enforcement to gather any belongings?
Yes, ma'am. Thank you. Yes, you do have the right to call law enforcement to go with you to get your stuff. There's two ways of doing it. One is you can have a friend go there and get your stuff, or you can call law enforcement and go with them. We just don't want anything to happen to you or to anything more to occur. So go with law enforcement or send a friend to get your stuff. And that's a one-time event. Thank you very much.
Então tá, então a fiança vai ser fixada em $500 e para você pegar as suas coisas, você ou pode pedir para um amiga ir buscar na onde você estava morando, ou ligar para a polícia e a polícia vai junto com você para pegar as suas coisas, tá bom? Mas isso é só para acontecer uma vez.
Tudo bem. Ok.
Okay.
Okay.
Thank you very much.
Your Honor, are you
Thank you,
appointing the
Junior.
Public Defender's Office on these cases?
Yes, thank you. I do appoint the Public Defender's Office for all cases this morning where the person does not have private counsel. So thank you very much.
Thank you for using our services. Bye-bye.
All right, thank you, interpreter.
My pleasure.
Next is McCree, M-C-C-R-E-E, Mr. McCree. You're arrested for a felony, a violation of probation, and we will notify the probation BOP court and send you to that court promptly. And so there's no bond at this point until you go to VOP court. Next,
This is gonna be interesting.
okay, next is Chapman, I believe, and this was, it has, are you Mr. Chapman?
Yes, sir.
Okay, so he's not been picked up. He was arrested for out-of-county warrant. They haven't picked him up. So State, how would we proceed with that?
Your Honor, as he has not been picked up by Lake County, and I have confirmed that they were advised of his presence here in Orange County Jail via teletype, I would ask that he be released, but that he report to the Lake County Clerk of Court within 48 hours of release.
All right, and we have no bond issue, we just release him?
ROR?
Okay, ROR,
I wasn't told anything else.
Okay. No, I just wanted to make sure. That's
okay. All right, sir, you'll be released ROR, which means on your own recognizance, which means really on your own signature. You are ordered to report to that county promptly and to take care of this. Otherwise, every time you come in contact with law enforcement, they're going to arrest you for an outstanding warrant. And so you need to solve that problem, okay?
Sir.
All right, thank you very much. Okay, next we have Jesus Plaza, mental health. All right, do you wish to waive or not? Public defender.
Yeah, I'm saying, think he can come tomorrow, or is he really bad? Your Honor, given that it is, I believe, a life offense.
Oh, these are capital offenses.
Yeah, I would ask that he be reset for tomorrow so that he knows what's going on.
Okay, all right, reset. Did I miss the page? Oh. Okay, let's see, Jeffrey Shasel.
Close enough.
Okay, close enough, good enough. Okay,
And, Your Honor, he was reset for a plea. The offer from the state was an adjudication of guilt, credit time served, no return till 4607 South Orange Blossom Trail in Orlando, Florida. And I would ask that you accept his no contest plea.
okay. Well, thank you. All right, I will be right back. I left my iPad in the office. I'll be right back.
Yeah. Doesn't seem so. Yes. Yes.
Okay, deal.
No, you didn't. It was self-evident.
Excuse me.
Okay.
Come to me now, you got in the office, come on, man.
Another bond hearing. I don't know. Please, that's why I brought him. Please. Okay, that answers that question. I'm like, why do I have an armed deputy behind me?
No.
Yeah. Okay. I'm like, fine.
So just relax. He just went to
No, because, yeah, we found like in the state statute, it's like, why are we granting people bonds if they've already signed a waiver of extradition? And it states in there that we're not supposed to. So.
If you bring that to my attention, I don't mind arguing that for you.
Okay.
It's just, I don't deal with extradition.
I know, and that's just it. It's like we are kind of like.
And
like
I'm gonna
the
check
other
really
day,
quick just to make sure you're.
Judge Jewett
Yeah, she was in
held
the
one.
Because I remember
on
when you couldn't
Tuesday,
come, I
and
let
didn't
her
know
know,
anything
or
about
the
it.
attorney know.
This is the same thing.
Okay, cool.
Good.
Thank you.
I don't see anything. Let me see. you have anything? No, let me just. Yeah, it does.
Okay. Sir, did you hear what your attorney said as far as the disposition of this case?
Yes, ma'am. Yes, sir.
Okay. And so, Madam Clerk, or I guess Mr. Clerk, in this case, will sentence him, will accept his no contest plea. Adjudication, time served is how much? 2 days, 1 day,
2 days.
3 days? All right, 3 days. Public defender fee?
No, Your Honor.
That is waived. The court cost is $273. So whenever there's a little different because of circumstances, tell me. And then you are to report to one of the courthouses in Orange County and to pay the $273 in full, or make a payment plan, enter into a payment plan. And if you fail to do that within 30 days, your driver's license and registration, if any, will be suspended until you pay the money. Do you understand that?
I do, Your Honor.
All right, thank you very much.
I'm good.
Oh, okay. All right, come on up, please.
I skipped it because I'm actually reading it.
The okay. Just that one page.
It's weird.
All right, thank you. Okay, next is Melissa Abbott.
Morning.
All right, Ms. Abbott, you are arrested for a felony, battery. There's three is a battery, and a burglary with an assault or battery therein. And so, state, especially the last one, burglary with an assault or battery therein, what's the suggested bond?
Your Honor, burglary with an assault or battery therein is a first-degree felony that is punishable by life. Generally, I would ask for defendant to be held no bond. However, based on the facts of this case and the defendant's criminal history, I have no objection to a $5,000 bond, Your Honor.
All right. Yes, I do see, for the record, she has no felonies, no misdemeanors, no failures to appear. The impression is she has no criminal background. So I believe the state's recommendation is reasonable, and so we'll go ahead and do a $5,000 bond, and then we'll do $1,000 for the count one, and then $500 count two, and then I've already addressed count three. You are to have no contact with the victim, witnesses, co-defendants, if any. You're not to have contact with them. You're not to. You are to live separate, and not to associate with them. So no contact, no return to the scene. Do you have any weapons, firearms, anything like that?
No, sir.
Okay. No firearms, ammunition, weapons, and anything else, State?
No, Your Honor.
All right. Thank you very much. Oh, I'm sorry. That was Melissa, right? Yeah, sorry. Okay, next should be Joseph Anderson. Mr. Anderson, first off, you're out on a surety bond of $500 for a DUI. We'll revoke that, and we'll go ahead and change that to be $1,000. And then you have new charges. So you're arrested for several felonies, aggravated battery with a firearm, aggravated assault with a firearm, a battery, domestic violence, and then 2 other batteries. And so the aggravated battery with a firearm, now let me, that's not an F1, is it?
No, Your Honor, that's an F2.
Okay. All right. Your bail amount there is $20,000. Aggravated assault with a firearm is $5,000. Then the battery, domestic violence is $1,000, and then battery, each of those are $500. Okay, you are to have no return to the scene, no contact with the alleged victims, witnesses, or co-defendants, if any. You are not to consume any drugs or possess any firearms, ammunition, or weapons of any sort. And so, all right, do you understand?
Yes, sir.
All right, thank you very much. Next is Cindy Cook. Ms. Cook, you're arrested for a felony, aggravated battery, and domestic violence. Is there anyone here to speak to that? There is not. I noticed that you have 2 felonies, a misdemeanor. There's never been a failure to appear. State your recommendation.
Your Honor, I would have no objection to a $1,500 bond.
Okay, all right, $1,500 bond, no return to the scene of the incident, no contact with the victim, witnesses, or co-defendants, if any, no, I do see some drug history, but so I'll just simply order that you be drug tested one time in 30 days, after 30 days, I meant to say. So after 30 days, I want you drug tested, and if you are dirty, then you will be rearrested and back where you are now. So I want you drug-free and to take care of this problem. Okay, and then no weapons. Did I state? Yeah, no weapons, firearms, ammunition, that sentence. Okay, and state anything else?
No, Your Honor.
All right, thank you very much. Oh, I'm sorry. I did not state the bond amount. Yes, I accepted your recommendation.
Yes, Your Honor,
of $1,500. Yes, all right. Okay, next should be Cassidy Noyola.
Yes, Your Honor.
All right, Ms. Noyola, you've been arrested for a felony, battery on a person 65 years of age or older. You have no criminal history. So state any reason why we wouldn't do $1,500. Oh, I'm sorry. We do have someone in the witness box. If you will begin with, tell me your name and spell your last name for the record.
Yes, my last name is.
Hold it. You can take off your mask.
My last name is Noyola.
All right. So, what's your connection to the defendant?
She is my daughter, Your Honor.
Your daughter?
Yes, sir.
Okay. We need to swear you in, please.
Raise your right hand. You swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I'm sorry, I have problems hearing.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Now, are you the person that was involved in this incident?
Yes.
All right. And do you fear your daughter?
I'm sorry?
Do you fear your daughter?
Normally, I don't fear my daughter, Your Honor. She's a good woman. I feel that she is bipolar and she lost her job and she wasn't able to afford her medications. I was trying to help her, to take her to look for interviews, but my wife, she got very sick and had kidney failure in the same time that I was trying to help my daughter.
All right. Do you wish for your daughter to return home? Is it safe for your daughter to return home? We don't want her to go back to a situation where she's just going to be arrested again, whether it's her fault or anyone else's fault. So we don't want to make her problems more. So can she return home safely?
Yes, sir.
All right. And so you don't fear for your safety?
No.
Okay. Ma'am, you heard that your dad says that you have some mental health issues, that you need your medicine, but basically you're a good person. Is that correct? Yeah. Okay. So,
Your Honor, she does qualify for pretrial release. I would ask for pretrial release, given the testimony.
yes, we'll do pretrial release. Now, I don't understand, there's no reason, you know, President Obama was, he was able to get through the Affordable Care Act and really helped America really great. The Affordable Care Act says that if you make a certain amount of income, if you have a low income, they will subsidize your medical insurance. So I want you to go online and see if she will qualify for the Obamacare, which is called technically it's the Affordable Care Act, and it really helps people. It was one of the most wonderful things. It's the same thing as I'm on Medicare. Thank God for Medicare and President Johnson. And so you need to get her the idea, this concept of the employer giving you insurance is so obsolete. It's like 1919. And so you need to get her on the Affordable Care Act, and it will subsidize low income, which she is right now. And so go do that today. When you leave me, go home, get on the computer, and get her signed up for the Affordable Care Act so that she can get her medicine. So you seem like a good man, and you seem like a good person. You have no history to suggest otherwise. So we need to solve this problem. And so let's treat it as a problem instead of as a crime necessarily, even though technically it is. So we'll release you on your own recognizance. If she's allowed to return home without any nonviolent, what's the right term I'm searching for?
No hostile contact.
Say again?
No hostile contact, Your Honor.
No hostile. You ought to be an attorney. That is great. You're so good on words. And I'm just teasing.
Oh, and Your Honor, you said ROR, it's pretrial release.
Oh, I meant to say pretrial release.
Yes, Your Honor.
All right. Well, thank you very much.
Yes. Thank you, Your Honor.
Yes, sir, and good luck.
Thank you.
Okay. Public defender, I was just joking. I didn't mean, you didn't take that as any kind of insult, did you?
Oh, no, Your Honor.
Oh, okay, yeah, I was just joking.
Yes, Your Honor.
For the moment.
Yes, Your Honor.
You know I like you and respect you.
Thank you.
Okay, next, are you Mr. Poole?
Yes, sir.
Okay, Mr. Poole, you are arrested for a felony, battery, domestic violence. We don't have anybody here. Battery, committing domestic battery by strangulation, false imprisonment. You do not have any felonies or misdemeanors or failures to appear, so it doesn't look like you have any history of any sort. State any reason we wouldn't do $1,500 on count one, and then $1,000 on count 2, and then $500 on count 3. And then you are not to return to the scene of this incident. You are not to contact the victim or witnesses. If you live at this place if you live there, you can go back one time to get your stuff accompanied with law enforcement, and then there's no drug history, so you are to be drug-free, and you are prohibited from owning or possessing any firearm, ammunition, or weapon. State, did I cover everything?
Yes, Your Honor. He does qualify for pretrial release. I believe defense is likely going to ask for pretrial release versus the monetary bond.
Okay. Unless, they're right, there's no reason not to be pretrial release. We'll go ahead and change with consent of the state to go ahead and do the pretrial release. Okay. All right. Thank you very much.
And Your Honor, did you give a one-time return on law enforcement?
Yes.
Thank you.
Yes. Okay, next, Gonzalez, Jennifer Gonzalez. Okay, Ms. Gonzalez, you're arrested for a misdemeanor, battery, domestic violence. For the record, there's nobody present to speak to this matter. She has no criminal history. Does she qualify for pretrial release?
Yes, Your Honor.
All right, so we'll go ahead and release her pretrial release. And at this point, you're not allowed to return to the scene of that incident. You can go back one time to get your stuff, such as clothing, cosmetic things, anything you need for work. But you need to stay away from the person, the scene. You're to be drug-free, and you are not to possess any firearms, ammunition, or weapons of any sort. State, did I cover everything?
Yes, Your Honor.
All right, thank you very much. Okay, next we should have Raymond Harris.
He refused.
He refused,
I
okay.
will waive, Your Honor.
Okay, we'll go ahead and terminate, revoke the ROR. And should I go ahead and give him a bond on that, what was an ROR, or to allow the judge that has that case to do it?
It is at your discretion, Your Honor. He was arrested back in June 28th, for a drug offense, and as of today's date, the state has not filed any formal charges, just to give you the necessary information.
And because of that, Your Honor, I would ask that you take no action on the out on bond.
I will, however, note, Your Honor, that he does have 24 felonies and 21 misdemeanors.
All right, but he was arrested back in June?
Yes, Your Honor, it was June 28th.
Well, I guess since there's been such a long delay, no, I'll go ahead and revoke the ROR and give him we'll do a $5,000 bond, look at the sale and delivery of meth, and just looking at that charge. And he has such an extensive history, I think that's a reasonable bail. All right, then we have his new charge is battery, domestic violence, And there is nobody here to speak to it. And so we'll go ahead and order that he have no contact with the victim or witnesses, not to return to the scene of the incident, except with law enforcement one time to get his personal items such as clothing and any work tools. He is to be drug-free. And looking at his history, it's full of drugs. And so I do order him to be drug tested after 30 days and then drug tested each month while the case is pending. It's not punitive. Is he not there?
No, Your Honor, I waived his appearance. He refused to come to court.
Okay. And so it's not, so that everyone understands, when I do that, it's not punitive. It's to try to keep them on the right track. Matter of fact, I talked to somebody today that sort of verified that it does help keep them on the right track. And so he would be drug tested, random drug testing each month while the case is pending. And
Your Honor, I would also ask for no weapons, no firearms.
say again?
No weapons or
Oh,
firearms?
yes, thank you. No weapons, firearms, or ammunition. All right, I think I covered everything.
Except the bond amount, Your Honor?
The, all right, we'll go ahead and do $2,500 on that. Okay, thank you very much. Right, next would be Rodriguez Colon. Okay.
Yes, Your Honor.
Say, is he Rodriguez Colon?
Yes, Your Honor.
Oh, okay. All right. I thought you said something else. All right. Sir, you're arrested for a misdemeanor battery. There's nobody here to speak to it. And so you do not have any criminal history. So does he qualify for pretrial release?
Yes, Your Honor.
All right, we'll release him on pretrial release. You are to have no contact with the victim or witness. Do not return to the scene of this incident except to get your personal items, such as clothing, no drugs, no firearms, ammunition, or weapons. Anything else, State?
No, Your Honor.
Your Honor, you said a no return to the scene. His daughter actually does not live with him, so could he have maintained separate residence and at one time return with law enforcement to make sure she's gone?
Right. So he lives. I didn't quite. He lives with his daughter, or his daughter lives with him?
No, his daughter doesn't live with him. She was visiting.
Oh, okay. Then strike the no return to the scene, because you should go back to your house, but she should not come. Is she gone back north? She was visiting?
She lives here, but she does not live with him.
Okay, all right. And so, you can have some relative tell her not to come to your house, leave you alone, stay away from you, because it would, so anyway, so you do have the right No contact with her. That's really what we want.
And Your Honor, just to be clear, the no, I would just suggest he not tell a relative because he can get violated for sending a message to her through someone else. So I think that if he goes back with law enforcement and she's not there, he can reside there. And if she comes to his house, he can just call law enforcement.
Okay, all right, yeah.
I don't want you to be violated. Okay.
Okay, did I?
Your Honor. Your Honor,
Yes, ma'am.
clarify, you wanted no contact, no alcohols and drugs, no weapons and firearms, but you kept the one-time return on there? Are you gonna?
No, do away with that, because that's not necessary.
Okay, are
Because
you
he
gonna do
lives there. It's his,
maintain separate residence or no?
yeah, just maintain separate residence, yes. That's, thank you for clarifying that. That's exactly your job, is to clarify, so thank you very much. Okay, next is Linda Brewer. Okay, Ms. Brewer, you are arrested for, it shows out-of-county warrant. Okay, it's Polk County. We have notified them, and they have a certain period to pick you up. Otherwise, you'll be back in front of a judge to be released. All right, thank you very much.
And Your Honor, she has a $500 bond, so she can post that bond here. If not, she will be transported.
Okay, yes. Yes. So like the lawyer just said, the public defender just said that you can post the $500 bond, and then we'll release you, and then you just report to Polk County. You understand? All right. All right, thank you very much. Next, we have, let's see, Walter Johnson.
Yes. Yes, sir.
Mr. Johnson, you're arrested for an out-of-county warrant from Osceola, and they're part of our jurisdiction, so we'll promptly send you to Osceola. Thank you, and there is no bond, and so you'll have to address a bond in Osceola.
Understood.
All right, thank you. Okay, let's see, Brandy Carter. All right, Ms. Carter, you're arrested for a felony, a violation of probation, and that is a no bond situation, and you will simply go to a VOP court and address the issues there. Thank you very much. Okay, we have Bradley Kershield.
Is Kershield, Your Honor.
All right, you have grand theft third degree, receiving money from a pawnbroker, When I look at your background, let me see. You have 7 felonies, 4 misdemeanors, no failures to appear. And warrants out of Virginia, Oregon, South Carolina, Nevada.
Your Honor, I would just ask that you stay the amount set on the bond, on the warrant. If you look, he's been in DOC. They brought him back here to deal with the new warrants, but he's been incarcerated, looks like, since September of 2018.
Right, so you're in Florida, the Florida DOC?
Currently, I'm incarcerated at Gulf CI. I mean, I'm here, Your Honor, yes. And I would like to be remanded back to DOC if possible to get my gain time, because I'm not able to get my gain time while I'm here. Also, a lot of my court paperwork for these cases are there. My legal research is there. my ability to access the court would be interfered by being here. And so I'd like to be remanded to the DOC.
Well, that's sort of beyond, because the state needs you and, for hearings, and your public defender needs you, and I'm sympathetic to what you're saying. I understand what you're saying. But really, now's not the time to make that decision. And so,
Your Honor.
all
There are
right.
also a couple.
And so, I tell you, we'll leave the bail amounts as is, because it's really academic, because he's in custody already.
Understood, Your Honor, but just for clarity, because there are so many cases, would you be kind enough to give the case numbers when you're doing the bond amounts and the charges?
Oh, on this particular one, or everything?
For him, Your Honor, I see that he has 4 separate cases. Some of them are no bond, some of them are different charges. The bond is set for all of them that are new offenses, but just for clarity, if you could just give the case numbers.
Okay, let me go through this then. Okay, all right, would it just be just as effective for everybody, the clerks and everybody, if we just simply said that the bail amounts stated in each of these cases will just remain, or do I need to go through each of them?
I apologize, Your Honor, but on occasion, you will have more updated information than I will, so what is stated on my paperwork may not match what you have on yours. I do apologize.
Okay, no. So what I have, okay, but the case that ends in 593, it is count 1, 2,500, count 2, 1,000, count 3, 1,000. Case that ends in 688 is 2,500 for count 1, count 2 is 150, count 3 is 150. And case that ends in 5667, it's a VOP, so there's a no bond, no bail situation there. And then the case that ends in 590, or that may be Orlando, maybe it's 659, is count 1 is 1,000, count 2 is 5,000, count 3 is 1,000, and that's the end. Did we cover everything you needed?
Yes, Your Honor, thank you.
All right, well, thank you.
I know that.
Okay, next is Martinez.
Can I also talk to you afterwards? Address some more things.
All right, Mr. Martinez, you're arrested for a felony, and it's a violation of community control. You will be sent to the VOP court and address any issues at that time. Thank you very much. Next, we have Pilgrim, Pilgrim, Mr. Pilgrim. And we have a VOP, so the only thing I have in front of me is a VOP, so that's a no bond situation. We'll send you to the VOP court promptly, and you'll deal with any issues there. Thank you very much. Okay, next is Pajol. How do you say your last name?
Pujols, sir.
Okay, and it's a felony, a VOP, so you'll go to VOP court. It's a no bond situation, so you'll go to VOP court and deal with whatever the issues are there. And you'll go there how long is it taking to go to VOP court these days?
Usually within 3 to 5 days, Your Honor.
Yeah, that's
I know
right.
that they have it on a Thursday, I just don't know
Right.
what the
Usually
interim
it's
date
about
is.
5 days. So you'll see the VOP judge in about 5 days and deal with whatever this is, okay?
Yes, sir.
All right, next is Mr. Smith. Mr. Smith, this is a felony. It's a VOP also. So within about 5 days, you'll go to VOP court and deal with whatever issues there are. So it's a no bond situation. VOP is not a bond situation. Next is Mr. Wilson. Okay, Mr. Wilson, you're also a VOP, so within about 5 days, you'll go to VOP court and deal with whatever this is, okay? All right, thank you. I think that's all that I have. Anybody else have anything? Oh, yeah, the clerk just handed me. We do have the 33-day. So the first one in front of me is Henry, and it's the last three are 4, 6, 8.
Denied, information was filed.
Oh, here's, I didn't give you, oh.
Good.
Raymond?
Mr. Perry?
Oh, Perry.
Because I have Jackson, Davis. Oh, it is Robinson. Okay, I finally see, I see that it is Robinson down here finally. Okay. Okay, next is, there's a bunch of names, but the one that appears that we've been able to verify is Robert, Roberson, or so Robertson.
Perry? I have Robert Perry from one bottle. On what list?
You want these two? Okay, let me see. Okay, this is Perry, so, okay, now we're together. Okay, our, next is Robert Perry. Mr. Perry, you're out on ROR, and so we'll revoke the ROR.
Your Honor, in regards to that, you have an add-on bond form. Can you take no action on that?
Okay.
Take no action.
Okay, as far as the ROR form goes, we'll take no action on that at the request. And then I guess the new thing is arrest for failure to appear. And so we'll go ahead and do a $2,500 bond.
Your Honor, it's another judge's capias. So state would request that it stay at no bond, as it came in as it is another judge's capias. Under the 4th TCA, IA judge can't change the KBS judge's KBS.
Okay, I apologize. I didn't, so we're leaving it at no bond.
Yes, Your Honor.
Okay, without objection.
I can't say nothing. I never even got a court date. Damn, man.
Next, Next is Robertson. Is this, this is, okay, here we have Kerry. But we don't, so I could just do this. All right, this is Robertson. We called this a few minutes ago, and this is another case.
Yeah, they was doing the move up.
Nora put the paper.
Okay, okay, this is Robertson, and this is a first-degree misdemeanor. Say again?
Medical. Okay.
Medical, okay.
It's medical.
For who? The arraignment?
Robertson.
I will waive and enter plea of
Denial.
a denial.
It's gonna be Division 82, VOP status would be October 10th at 9 o'clock in courtroom 9B.
Oh, there's several.
First one, Robertson.
Oh, okay.
Thank you.
All right. Then we have another move up for medical, right? And this is Chambers, Jason Chambers.
And I will waive your, oh, are we appointed?
Do you want to appoint the PD?
Your Honor, I would ask that you appoint us, and then I will waive and enter plea of not guilty.
All right. The public defender is appointed for all cases this afternoon where there's no private counsel. Okay, and then
The pretrial would be in Division 85, October 3rd at 9 o'clock in courtroom 4A.
next is Crittenden, Dana Crittenden.
And I will enter plea of not guilty, Your Honor.
Okay,
Pretrial date will be in Division 82, November 9th at 9 o'clock in courtroom 9B.
okay, and then the arraignment of, well, I guess it's I'm not sure, is it Davis or Kadisha or Deshay?
Davis is the last name.
Davis is the last name, okay. Davis will enter a plea of not guilty and a trial date, please.
I will waive and enter denial.
Division 50, October 17th at 9 o'clock in courtroom 4E.
Gina Marie Mullins, Mullins.
She got time served, Your Honor. She's not in jail.
So she's been released and sentenced?
Yes, Your Honor.
Okay, so she's no longer in jail. Okay, very good, thank you. Lindsay Ashton, last name Oliveira. Oh,
And I will waive and enter a plea of not guilty, Your Honor. Oh, she wasn't served. So return to the state.
All of her served.
Return to the state for service.
yeah,
Yes, I
we'll
would ask that
appoint
you
the PD in all of them. Yes. And that was a plea of not guilty?
Yes, Your Honor.
Okay.
Oh, well, I can't enter a plea until she's served. This, I asked that it be returned to the state to perfect service. And the state said they're going to make sure they serve her.
Okay, so we're all good?
Yes, Your Honor.
Okay. All right, Jermaine Summers.
Medical. And I will waive and enter a plea of not guilty, Your Honor.
Okay.
Division 81, pretrial will be October 14th at 9 o'clock in courtroom 6B.
Anthony Waller.
And I will enter a plea of not guilty as to his battery charge, Your Honor.
VOP status will be in Division 81, October 17th at 9 o'clock in courtroom 6B.
Okay. Let's see. This says Sabrina Kerry. Okay. Ms. Kerry, you are arrested for a misdemeanor of battery. And And so the couple of people that are, or one or two people, I can't quite tell, that is out in the audience, when we call the case, if you wish to speak in regards to that case, just stand up, and there should be someone out there who will help you go into the box. But I need for you to stand up so I see that you want to talk about that case, and then someone will help you. Okay, next is Sabrina Kerry, and we talked about battery, and looking at Sabrina's background, the battery on law enforcement. All right. She has defendants, let's see. All right, we'll change it to be $1,000. I'm increasing it because as you have background, as you have more arrests in your background and convictions, that increases your bond or your bail. And so the bail is changed from 500 to 1,000. And she is to have no contact with the victim, witnesses, or co-defendants, if any. And she's to be she's to be drug tested at least once. We'll do drug test once, and no weapons, no firearms, that is, and ammunition. Anything else, State?
No, Your Honor.
Oh, there's another case here. Madam Clerk, is this another case? No? Okay.
You're welcome.
That's what I was looking at. Okay, next is Peter Donnelly. Mr. Donnelly?
Yes.
You've been arrested for a misdemeanor. It's a battery, and looking at your last conviction, there was fraud back in 2013, disorderly intox. All right. There's not enough to increase, so we'll leave it at the 500.
Can I get released on ROI, please? I'll be stuck in here. Your Honor, I swear I'll be good. Can you please release me on a ROI?
Your Honor, State would object to ROR.
I couldn't. Okay, and also my address is incorrect for your paperwork.
Okay. All right. We need to make a note of that. We'll get a good address so you can receive notices.
30 days.
All right. Pretrial release, is there any reason that he doesn't have pretrial release?
Your Honor, State would object to PTR even if he did qualify for it. Given the allegations within the affidavit, State would just ask that you set the stay of the bond with a no contact.
Okay, let me just.
I want to say, Your Honor, if you want to, you can do a bond or PTR. I guess they didn't verify his community ties, but.
Okay, let me just.
Please, Your Honor.
right, we'll leave the bond as is, the $500 bond. That he's to have no contact with the victims and no firearms or ammunition, no drugs. All right, next, next is Jamal Harris. Mr. Harris. Jamal Harris. Mr. Harris, you're arrested for a misdemeanor, trespass on property after warning, and
Your Honor, state did convey an offer to Mr. Harris of an adjudication of guilt. 7 days OCJ with 2 days credit time served and no return to Copley I.
is that acceptable?
Yes, Your Honor, he will, accept
All right. Sir, did you hear what the state attorney said as far as taking care of this case? And do you want to accept the plea offer?
Yeah.
And so, is there any cost of investigation?
Not that I know of, Your Honor.
Okay, then we'll accept a no contest plea. We do adjudicate times. He is sentenced to serve 7 days with credit for time served. Did you say 2 days?
2, yes.
2 days. All right. Public Defender Services is $50. Sir, do you?
I would ask that you not appoint us, given that he's accepting a plea.
Okay, all right, that's fine. It's your money.
Yes, Your Honor.
And then the fine, Madam Clerk, what's the fine? I'm sorry.
Court cost.
We don't need to do a fine. What is the court cost? $273. Okay, and then, sir, I order you to pay that $273 within 30 days, and either pay it in full or enter into a payment plan with the clerk of court at one of the courthouses. Just go to any courthouse and pay the fine or enter into a payment plan. It has to be done within 30 days. If you fail to do that, then your driver's license and any motor vehicle registrations will be suspended. Do you understand?
Yeah.
All right, thank you very much. Okay, next we have Mark King. Mr. King?
Sir.
Okay, you are arrested for a misdemeanor, failure to appear, and we'll go ahead and revoke his bond.
Your Honor, state would just ask that you stay the bond on the failure to appear, the 500.
All right. We'll leave it as is, and anything else?
No, Your Honor.
Okay. Next is Carlandra Roberts.
Yes, sir.
All right, Ms. Roberts, you are arrested for a misdemeanor, is possession of drug paraphernalia and providing a false ID to law enforcement. And looks like you don't have much of a history yet. You know, every time you get arrested, from a judge standpoint, you pose a risk to society, and so your bond will, or your bail will be higher each time, and then eventually you'll go to prison, and you'll probably, you just have a very difficult life. So, I say that only because you are a high school graduate, and you don't have much of a history yet, and so, anyway, we'll leave the bonds as is. They are reasonable given her background yet. Okay, and then I do want you to be drug tested periodically, drug tested monthly while the case is pending. I want you drug-free, and I want you to take care of this. Otherwise, you're going to just wind up in prison. So I'd like to keep that from happening. Okay. No firearms, no ammunition, and no return to the scene. Anything else, State?
No, Your Honor. However, she does also have a out-of-county BOP.
Oh, she does? All right, we will notify the out-of-county that you are now violated your probation, and you're going to have to deal with that. All right, thank you very much.
Is it staying at 9?
I have a question.
Yes, ma'am?
For the,
And Your Honor, just for the record, the VOP is staying at none.
Is where?
The VOP is remaining at 0 bond.
Oh, yes, yes. Yeah, whenever I forget to say something like that, please, thank you for doing that. I appreciate it.
No problem.
She has the bond.
Okay, folks, we have to move on. We've got a lot of cases to deal with today. All right, next, please bring in Jeffrey Shachel, S. His behavior, okay, we'll.
We reset for tomorrow. There's an offer to resolve this case, Your Honor.
Okay. Next is Donald Toldson. I do see where he's out on surety bond, and we'll.
Your Honor?
Yes,
There's actually an offer to resolve the trespass. The offer from the state is an adjudication of guilt, credit time served, and no return to the Orlando International Airport without a valid ticket. And Mr. Toldson would like to accept an enter plea of no contest. In exchange for accepting the state's offer, I would ask that you take no action on the out on bond.
okay. Not state, but defendant, did you hear what she said?
Yes, sir.
Do you agree?
Yes, sir.
All right, and we'll go ahead and enter a plea of no contest. We do adjudicate we'll sentence him to time served. What is that?
2 days.
2 days. We did appoint the public defender. The $50 fee?
No, Your Honor,
Okay.
not on the pleas. So.
On these pleas, why don't you tell me when, I don't know, when do you want the fee or when don't you want it?
On everything else, if we're already appointed, but just since they're just pleading to the misdemeanor pleables and we're not doing anything else,
Okay.
I just don't want them to have all those fees.
Okay, and then the court cost is $273, unless the clerk tells me otherwise. And then, sir, you are to go to one of the courthouses and either pay this $273 or enter into a payment plan with the clerk's office. If you fail, and that has to be done within 30 days. If you fail to do that, then your driver's license, if any, and motor vehicle registrations will all be suspended until you pay that money. All right, thank you very much.
Honor,
And no action on the out on bond, Your Honor, correct?
Right.
Thank you.
Okay, and Victoria Walter, Ms.
Was a refusal?
I couldn't
And I
understand.
will waive. I will, oh, sorry. I will waive, Your Honor.
Okay, all right, and
State would just ask that you stay,
all right.
stay the bonds and do a no return.
All right, we'll go ahead and stay the bonds and no return, no contact with the victim, stay, no drugs, no firearms or ammunition.
Mhm. I know that's what they said. You want to just reset for tomorrow? Do you think he's gonna come? Yeah, we'll just.
Okay, next we have James Douglas.
We'll skip.
Mr. Douglas.
Can you set Mr. Douglas to the side? He's not up here yet, he's on the.
Oh, okay, all right. Yeah, just tell me when he's here. Next, we have Cecily Jackson. Ms. Jackson, you're arrested for a misdemeanor, urinating or defecating in public, and
Your Honor, state did convey an offer to Ms. Jackson of an adjudication of guilt, credit time served.
all right.
How many days served?
All right, do you want me to bring her back tomorrow?
No, Your Honor, she's fine. I just wanted to make sure, because she wasn't brought up yet at the time.
Oh, okay.
But she would like to accept the state's offer.
All right, we'll do a no contest adjudication, and time served, 2 days?
Yes.
All right, 2 days, and court cost of $273, thank you. How much?
$223.
How come it's lower?
This is the order.
Oh, it's an ordinance, oh, okay, thank you, yes. Okay, and then, ma'am, you are to go to one of the courthouses and pay in full to the clerk the money that's due, or enter into a payment plan. You have to do this within 30 days. If you fail to do that, then your driver's license, if any, and motor vehicle registrations will be suspended. Thank you very much. Next, we have Jose, let's see, Echeverria, something like that.
That's good enough, Your Honor.
Okay, thank you. You're arrested for a misdemeanor and then a failure of defendant to appear in court. Is there any resolution?
No, Your Honor, state we just ask that you stay the bond.
Okay, all right, we'll stay the bond as is.
It's not right.
Next is a this is a Hall, and then, but I have Richard Vincent. Did I say again? Bonded. Oh, okay, Mr. Hall bonded?
Mr.
Okay.
Vincent bonded.
Mr. Hall bonded as well.
Oh. Okay, great, thank you very much. Here's Vincent. Okay, this is, all right, let's see, Kernile, at Hanasi?
Cornel Athanase?
Okay, all right, sir, you are arrested for a felony aggravated battery with a weapon, and I think, is this the one that's a knife? Yeah, a
I believe
knife,
the victim grabbed a knife, the defendant grabbed a bat.
right. And so, looking, yeah, it doesn't look, I'm surprised that there's no history at all, given the facts of the allegation. And state your thoughts about bond amount and any special conditions.
Your Honor, state would ask that you stay the bond. I believe that's consistent with the bond schedule. It would ask for a no contact with the victim, Debbie Ryan, and a no return to the 7-Eleven and no weapons.
Right. Okay. All right. We'll accept that.
But I know he's gonna.
We stay the bond. No contact and with the victim and no return to the scene, and no weapons, firearms, ammunition. Next, we have Christopher Baker. He bonded? Yes, sir. Okay, bonded. Christopher Baker.
And I have Mr. James Douglas, who we passed.
Then I have, did you say Peyton Baker?
No, sir.
Oh, okay, all right.
And
Let
Your
me,
Honor,
okay, that's who we wanted to do before. Okay, got it?
The offer is an adjudication of guilt, credit, time served, and Mr. Douglas would like to accept it as a plea of no contest.
All right, sir, do you agree with that? Okay, then we'll go ahead and enter a plea of no contest. Adjudication, time served is 2 days?
1 day.
1 day, all right. And the fine, pardon me, not the fine, but the court cost is $273. How much? It's $223, okay. And oh, okay. It's $223. Sir, you are to go to one of the courthouses and pay that amount of money, the two, what'd you say? 23? through 23, okay. And, okay, or enter into a payment plan. If you fail to do that within 30 days, your driver's license and motor vehicle registrations, if any, will be suspended until you pay the money. All right, thank you. Okay, next is Peyton Baker.
Sir.
All right, Mr. Baker, you've been arrested for a felony, a carjacking, and then when I look at your, say,
He must have bonded.
Department, DOC was released in 2010, and then we have some, we do have a gun, ammunition, cocaine.
Hold on, a gun and what?
Let's see, when you went to prison, did you go to prison?
Hold on, no, that's not me.
I don't believe he has any
I've never
DOC
been to
time, Your
prison.
Honor.
Oh, I'm sorry, is this Christopher Baker?
No, that was the one that bonded. He bonded, Your Honor.
I'm sorry, I didn't hear.
Peyton Baker.
I didn't hear that
Qualified for
was
PTR?
being said.
On my paper, it says PTR.
Okay, this is Christopher Stephen Baker.
No, my name is Peyton Lee
And
Baker.
then Peyton Baker, okay, that's, all right. Now we've got Peyton Baker. All right. Mr. Baker, it's carjacking, and you have 6 felonies, 24 misdemeanors, 7 failures to appear, 40 unknown, Florida convictions, and so we'll change that carjacking to be $50,000. So the amount of money goes from $20,000 to $50,000, and he is to have no contact with the victim, no contact with co-defendants. He is to possess no firearms, weapons, ammunition. All right, State, is there anything else?
No, Your Honor.
Okay, next we have Krishan Barnes, B-A-R-N-E-S, Mr. Barnes. Okay, this is a felony, possession of cocaine, possession of drug paraphernalia. Okay, and okay, I guess the ones that we have today, so we'll go ahead and change that. The possession of cocaine, we'll go ahead and change that to $2,500. And the possession of drug paraphernalia, $1,000. And then he is to not return to the scene of the incident and to be drug-free, no weapons, firearms, ammunition. Thank you. State, anything else?
No, Your Honor.
Your Honor. Your Honor, did you mean to say you want him to be drug screened? Or no? 'Cause I thought I heard you say that.
No.
Okay.
Okay. Next is last name of Cain, C-A-I-N. So, Mr. Cain, you have a felony, petty theft, 2 prior convictions, and you have 3 felonies, 12 misdemeanors, And so we'll go ahead and change the bond to be $1,000, that he's to not return to the scene of the incident, no contact with the victim, to be drug-free, and then no firearms, weapons, ammunition. Anything else, State?
No, Your Honor.
I think he said he can be drug-free.
Next, we have Deborah Carter.
Hi, Your Honor.
Ms. Carter?
Yes.
You're arrested for a felony, possession of cocaine, possession of drug paraphernalia. You have 6 felonies for 0 misdemeanors. Your last conviction was back in '03.
Your Honor, State would just ask that you stay the bonds.
Yeah, the bond appears reasonable. I agree. So you are to not return to the scene, no contact with a victim witness, and to remain drug-free. And because of the history and the charges, we'll go ahead and have her drug tested each month, beginning in 30 days from now, until each month until the case is disposed of. All right, thank you. Next, we have looks like Maurice Castaneda. No, I'm sorry, Carter. Yeah, Castaneda, Maurice Castaneda. Sir, you're out on a $2,500 bond for sex offender violation, failure to register. We'll revoke that and change it to be $5,000. And then is there the new charge is you now have a felony charge of possession of meth, and the bond is $1,000, and we'll leave it as is. And you are to have no contact with the victim, no return to the scene of the incident, and to be drug-free, to not have any weapons, firearms, or ammunition. State, anything else?
No, Your Honor.
Okay, next we have Gwenson Kluger. Okay, Mr. Kluger, you're arrested for a felony. It's possession of meth. Okay, the standard bond of $1,000. You have 9 felonies, 12 misdemeanors. And so we'll go ahead and change the 1,000 to be $5,000. $5,000 with those conditions. Next we have Lauren Collier. Refused to come?
I will waive, Your Honor.
Okay. And grand theft, 3rd degree. It's a felony. He doesn't have much of a background in terms of prior offenses. What's your thoughts, State, on that bond amount?
State would just ask that you stay it with a no return.
All right, we'll leave it as is. Oh, I see, it's a warrant.
Mm-hmm.
Okay, I didn't see that at first.
Your Honor, she also has another case, a VOP from out of county.
Okay, we'll go ahead and send her to the VOP court, no bond. Next is Courtright.
Bonded.
Bonded, okay, thank you. The attorney, what case is he here for?
Your Honor, I'm here on Jonathan Fort.
For who?
Two more people ahead of him, and he's coming in.
Thank you, Your Honor, I appreciate it.
Okay, all right, next, we have Benny Daniels. Mr. Daniels?
Yes, sir.
Okay, first off, you're out on bond. Possession of cocaine, we'll revoke the bond, and we'll set a new bond at $3,000.
Your Honor, on that, he has two charges.
So
On
could
the
we,
out on bond, he has two charges.
Oh, he does? Oh, okay.
could we do 1,500 on each count, Your Honor? That would equal 3,000.
Okay, so, because this says $1,000, so you're saying,
He has possession of cocaine and possession of cannabis less than 20 grams.
okay, so we'll do the $3,000 for the felony and then $500 for the misdemeanor? Okay. All right, so that takes care of the bond he was out on, and now he's, again, possession of cocaine, possession of cannabis is the new charges, so it's the same thing again. So we'll go ahead and the possession of cocaine charge will change from 1,000 to be 5,000, and the possession of cannabis we'll leave it as is. And he is to not return to the scene of the incident, no contact with the victim or witnesses, and to be drug-free, and to not possess any weapons, firearms, or ammunition. State, anything else?
No, Your Honor.
Okay, we have Kayla Davis, and, all right, Ms. Davis, you were arrested for a felony, failure of a defendant to appear in court, and that's a new charge. And so we'll go ahead and set a bond.
Your Honor, it's a failure to appear. It's a KPS. State would ask that it remain at no bond pursuant to that other judge's KPS.
Okay, defense? All right. We'll leave it at no bond, and in other words, the underlying case that she failed to appear on, that judge will take care of the bond?
Yes.
Okay, all right. All right, thank you very much. Next, we have Haley Dubois. Thank you. Next, we have Willard Ellis.
Yes, sir.
Mr. Ellis, you were arrested for possession of meth, and we'll go ahead and leave the bond as is, and you are to not possess any weapons, firearms, or ammunition, not to return to the scene of this incident, and to be remaining drug-free. Thank you very much.
Your Honor, he has another case as well.
He does? Okay, let me see where that is. Okay, all right. Well, no.
Yes, he has another case.
He has a second case?
The soliciting charge, Your Honor?
Soliciting without a permit, the county case.
Okay, I guess bring him back, soliciting without a permit. The bond is $150, we'll leave it as is.
Thank you.
Thank you. Next is Jonathan Fort.
Good afternoon, Your Honor.
Good
For the
afternoon.
record, Ken Yule on behalf of Jonathan Fort.
Okay, has a bond of petty theft, $250. And then he has pretrial diversion, battery on a law enforcement officer. So we'll go ahead and revoke those. And the petty theft that had a bond, we'll change that to be $500. And then the new case is possession of cocaine and grand theft third degree with a firearm. So did you want to say anything about that?
Yes, Your Honor. With regard to the bonds that were revoked, I would ask that we set a bond that's maybe double the previous amount. I know that when we look at kind of the conditions of release that are appropriate, even when a person's out on bond, I know that the presumption for many judges is to automatically revoke, but I think that we can look at, are there conditions of release that can still satisfy safety to the community, showing up for court, things of that nature. If we look at Mr. Fort's history, although there's a couple of that are all kind of grouped together, we don't really have an individual that has a long string of history. And speaking just based off of early discussions with prosecution, I don't think that any of these cases are going to resolve with any sort of jail resolution. Right now, the current offer, and again, I think it might change given the fact that he's here, is pretrial diversion. But I mean, I still think that that's a very reasonable expectation for probation in a case like that. I would ask maybe, Your Honor, create some additional conditions. We can add pretrial release with, weekly testing and double the bond amounts. But I do think there are conditions of release that can ensure the safety. I don't think that Mr. Fort is a inherently dangerous person. I don't think that he is a risk to not show up for future court appearances. So I do think that there is an ability for Your Honor to craft something here. Back in the day, it was very easy because what we used to do is and I'm sure you're aware, automatic GPS monitor put on, and that would solve everyone's problems when a person picked up a new thing. Problem is we don't have that ability anymore. But I do think that we still have some leverage to make this happen.
All right, the possession of cocaine, we'll leave it at the $1,000. Possession of a firearm is $20,000. And you are not to possess any firearms, ammunition, or weapons. And so the gun, possessing that gun, for whatever the circumstances, I read the allegations, that gun is going to cost you $20,000 bail, which is a $2,000 fee. And so that's the main focus. So, much of what your attorney said is reasonable, but once a gun becomes part of the mix, that changes the whole thing. And so I was sort of surprised to see no felonies and no misdemeanors. But once you throw guns in, that changes everything. And so...
Your Honor, he also has another case, a Dwillis.
Okay, let me... Oh, yes, okay, thank you. And this is driving while with driving with a license suspended with knowledge, it says. So the bond is $500. We'll leave it at $500.
And Your Honor, in regards to his out on bonds, you revoked and you set the petty theft at $500. However, you didn't state anything as to the Bat Leo.
As to what?
He was out for two cases, the petty theft and the Bat Leo. You revoked and set $500 on the petty theft.
Yes.
However, you didn't do anything for the Bat Leo.
Right.
Originally, it came in at $2,500. But since he was on PTD,
Okay.
it was
All right,
discharged.
we'll go ahead and change that. So that, the bond amount is not put on the form here. That's one reason I didn't address it. So that bond actually was $2,500?
When he was originally arrested on it, it was $2,500, and then he was put into PTD, so it was discharged. So if Your Honor is revoking, state would ask that it be at $5,000 as it originally was at $2,500.
All right, we'll go ahead and do that. So it's a $5,000 bond. All right, thank you very much.
Thank you, Your Honor. Thank you for your time today. Have a great day.
Yes, sir. Okay, we have Andrew Golden.
Medical, Your Honor.
Okay. All right, we'll reset.
Your Honor, as currently charged, it is a PBL. It's a golf cart.
I know, that's what I'm saying.
Is that a conveyance?
Are you asking?
Your Honor, can I have 1 second, please? As currently charged, count 1, the armed burglary of a conveyance with that knife is a PBL, which will be a first-degree felony, which state would be asking for no bond on. However, reading the affidavit, the conveyance allegedly is, I believe, a golf cart, which I do not know is actually a conveyance under the Florida statutes. I just wanted to verify that real fast before state asks for no bond. Motor vehicle, ship, vessel, railroad, vehicle, car. I mean, I would assume a golf cart is a motor vehicle. As a motor vehicle, as a motor and or tires. It's an interesting one, Your Honor. It's not a standard burglary of a conveyance with a weapon, which is an F1 PBL. However, state will leave it within your discretion whether or not to hold him no bond. I believe you can legally. However, I'm not sure if the facts warrant it. So state will leave that within your discretion.
All right, I did read the facts, the overall, and the weapon was a knife, and the flashlight and all of those other things involved in the facts. We'll go ahead and put a bond of $20,000. And then armed trespass is $1,000. That's fine for the facts. And then the petty theft is the $250. That's fine too, because the main focus is that count 1. And so then we have no contact with the victim or witnesses, no return to the scene of the incident, drug-free, and no weapons, firearms, or ammunition. Anything else, State?
No, Your Honor.
And I will waive.
Okay, we have Satan Harrison. Is that your first name?
Satin Harrison.
How do you spell your first name?
Satin.
Okay. And So Ms. Harrison, you were arrested with a felony, grand theft, third degree. And when I look at your background, you have 6 felonies, 8 misdemeanors, 7 failures to appear in court, and 25 unknowns. And so we'll go ahead and change her bond to be $10,000.
On which case are you talking about, Your Honor?
And so it's $10,000.
Your Honor.
She has 2 grand thefts, so which one are you changing the bond on?
Okay, okay, let me look here with the paperwork. Okay, all right, yes, I need to clarify. So I'm going to do 10,000 and with her background on both of them. So she has 10,000 in each of them.
Your Honor, I would ask that you actually stay the bond that was set. If you look, she's been incarcerated. Looks like it says she's supposed to be released from DOC on the 18th. I'm assuming these are old charges. So because of that, and another judge issued that warrant and set $2,500 and $500, and she's been incarcerated for about 2 years. It looks like it says from February 23rd of 2021 until the 18th of this month. She's not going to be able to afford $10,000 on each count, which is tantamount to no bond at all. She's been incarcerated all that time.
Your Honor, if you are inclined
Are
to...
these how, I don't understand.
On the 11538 petty theft, or grand theft rather, that case was filed back in August of 2021, and it's been in KPS since, most likely because she was incarcerated. The date of incident on that 2021 case is July 22nd of 2022. I believe it was a grand theft from Bath and Body Works.
How could it be of 2022?
Or 2020. I'm sorry,
okay.
I misspeak. 2020. It was July 22nd of 2020. It was a grand theft from Bath and Body Works. It was $2,898 allegedly stolen. So that one is an older one. If Your Honor is inclined to raise her bond, say would ask that you stay the $2,500 on the 11538. And if you are inclined to raise her bond due to her history, say would just ask that you raise it on the 9919 up to $2,500 as well. So her total bond would be $5,000 instead of 10 on each case.
Okay, all right. I'll accept that recommendation. So on the one that ends in 538, we'll leave it at 2,500, and then the one that ends in 919, we'll change that to 2,500 also.
And Your Honor, stay would ask for no return on both.
Right, correct. All right, thank you very much.
You don't have to stay.
Okay, we have Marvin Hill. Mr. Hill, you're arrested for a felony, failure of defendant to appear in court. And state, what do you want me to do?
Your Honor, state would just ask that you stay the $2,500.
All right. I do see KPS was issued, so we'll leave it as is. All right, thank you very much.
Your Honor, I'm so sorry. I wanted to go back to a case that we did in the beginning to clarify. On all your RUAs, are you wanting them to be drug tested once a month? Because on one, you only stated you wanted her to be drug tested at least once.
Right.
Did you mean once a month? On Sabrina Kerry, a misdemeanor pleable?
No, I remember thinking that. Yeah, I know what you're speaking about. No, I just wanted her drug tested once.
Okay, all right, thank you.
Just one time after 30 days.
After 30 days.
Yeah, to give her time to get her system clean, and then we'll see what happens. But the others would be once a month during the duration of their case. Okay, next would be Richard Jackson. Okay, Mr. Jackson, you possession of ammunition, possession of cannabis over 20 grams, possession of drug paraphernalia. So apparently, the bond amount is $5,400, if I'm reading this right.
And that's on the 9856 case for Madam Clerk.
I'm confused. All right. So the total bond is 5,000.
400 is what it came in as, yeah.
Your Honor, as to case number 2022 CF 3898AO that he's out on bond, he was arrested April 7th of this year. The state has yet to file charges. He was actually released on a 33-day motion, so I'd ask that you take no action given that we're in September.
He also has a private counsel for that one.
Mm-hmm.
So on these two bond notices that he's out on bond, then one is ROR, and it does show trafficking in oxycodone, 4 grams with a firearm, possession of a firearm, and then carrying a concealed firearm. So that is the case that ends in 684 and
898, Your Honor.
The new case is the 684, Your Honor, the possession of cocaine. The out on bond, the trafficking with the firearm.
Okay, the reason I said, because up here, it says the 22 CF 10684A. So this is a, right, he's out of ROR, so this is not this isn't the new case? Okay, so we have 3 cases?
He has 2 out on bonds and 1 new law.
Okay. Looking at the one that is 684, possession of cocaine, we'll go ahead and raise that to 5,000. And then the one that is 898. Okay, 898. That was an ROR.
That was subject to a 33-day motion that he was ROR'd.
Okay, so we need a bond there. We need a bail there.
Your Honor, I'm asking that you take no action given that the state has not moved forward on formal charging. And that, again, I would just note that it's back in April when he was arrested and we're in September and they still have not charged.
That is correct, Your Honor.
Well, you know, I understand your point. That's, you do have to wonder about that.
I believe there's been movement on the case. I see notes from the ASA charging it. However, something has not been formally charged yet. I believe they're still going back and forth with law enforcement to get, from what I see, one particular thing, which I think is what they're waiting on to charge it. I don't know that for sure, but that's what I see.
Yeah, it would be somewhat inconsistent, I guess, if we have the 33-day and I were to do a high bond, and the state hasn't been doing anything on it. So, so public defender, I accept your logic. So then we'll leave the one that is 898 as is, and the one that is 856, which is $5,400. No. It's $5,400 is the bond amount, and so It has 4 counts: possession of ammunition. We'll go ahead and make that a $20,000 bond. The count 1, possession of cannabis with intent to sell, would do it $5,000. Possession of cannabis greater than 20 grams at $5,000. Possession of drug paraphernalia at $2,500. And I think we've addressed all the issues. Okay, and then the condition of that bond is no contact with co-defendants, witnesses, no return to the scene of the incident, remain drug-free, and I do want him drug tested each month during the duration of the case, and if you find you're drug tested after 30 days, and anything else, State?
No, Your Honor.
All right, thank you very much. Okay, next we have Chancellor James. James is the last name, Mr. James?
Yes, sir.
All right, this is your ROR. Let's see, possession of a FD, what?
Firearm?
By a delinquent.
All right, what's the D?
Delinquent.
I can't hear the
A
word.
delinquent. So it's convicted felon, but a convicted delinquent,
Oh. Okay,
which is an F2. In possession of ammunition by a convicted delinquent, which is also an F2. It was ROR due to a 33-day motion, however, state has since filed.
okay, then we need to, so there's 2 counts. And so I would go ahead and do on count 1, the 20,000, and then on count 2, which is ammunition, we can do on as 10,000. And so that's the case that ends in 353. And then we have a new,
Your Honor, I will waive the reading of the new charges.
okay. And then the new charges, is that a life felony?
Yes, Your Honor. Count 1 is a first-degree felony that's punishable by life. So state's requesting that it stay at no bond pending an Arthur hearing at a later time. And count 2 is an F2. So state's requesting that you set a reasonable bond as to count 2.
All right. Count 1 would be a 0 bond at this time. And count 2, we'll go ahead and do that at a $20,000 bond. He is to have no contact with the victim, no return to the scene of the incident, to remain drug-free, no possession of weapons, firearms, or ammunition.
Your Honor, state would ask for no contact with any minor under the age of 18.
Right, and okay. In the case that is 705, I guess that is, or trying to read the language, I mean the numbers, and there would be no contact with minors. Anything else, State?
No, Your Honor.
Thank you.
Especially here.
Okay, now we have Keita Justine. Justine?
Jean Time.
Jean Tyne? Okay.
Judge, I was arrested for no reason. I didn't do anything wrong. Can you set me
Okay.
up a bond?
Okay, this is, you're arrested for felonies. It's failure of defendant to appear in court 1 time, 2 times, 3 times. And so you apparently have an outstanding criminal case and you have failed to appear. Okay, that underlying case is resisting an officer with violence, battery on a public transit employee, battery on a law enforcement officer. That's the reason you were originally arrested, and then you failed to appear on those cases, or on those charges, I mean. So, State,
Your Honor, given that it is a failure to appear, state would request that it stay at no bond, and let the trial judge
okay.
determine a bond.
All right, I'll leave it at no bond. You will be brought before the judge that has the case that I just described, and he and you can have a conversation about what's going on here. Thank you very much. Okay, we have Sean Johnson. Okay, Mr. Johnson,
Yes, sir.
you're arrested for a felony, the sale and delivery of cocaine. And let's see, let me look at your history.
I've been in trouble almost 20 years, sir. Can I get ROR, please, sir?
No, you don't qualify.
You do have a failure to appear out of state.
Long time ago, sir.
Your Honor, that warrant is still open, I believe.
They told me as long as I didn't come back, they weren't going to come find me and they weren't going to mess with me. It was agreement with the state.
Yeah, I see where the warrant is back in '07. So just stay out of Pennsylvania?
Yes, sir. That was the agreement with the courts. I've lived in Orlando my entire life. I've been born here, raised here. Can I please get an ROR, sir?
Okay,
Your Honor, state would ask that you stay the bond as it's currently on the warrant. The bond schedule comes in at $15,000. So I believe the law enforcement officer, when authoring the warrant and the judge signing the warrant, took into account for his lack of criminal history by half of what
Okay.
the bond schedule comes in at. So state would ask that you stay what's in the warrant.
all right, that's a reasonable request. So we'll leave the bond at the $7,500 for the reasons stated by the state. And he is to not return to the scene of the incident, not to contact any defendant, co-defendants, witnesses, to be drug-free. And so let's go ahead and have him drug tested in 30 days after his release, and each 30-day thereafter while his case is pending, and no firearms or ammunition. I think I may have said that. Thank you very much.
I don't have a way of bonding out, so.
Okay, next case is Lopez Rubio. Lopez Rubio, sir, you're arrested for a felony, conspiracy to commit first-degree murder, attempted first-degree murder with a firearm, aggravated battery with a firearm, aggravated battery with a firearm, and let me see if there's...
Your Honor, count one, I believe, is just a first-degree felony. When you conspire in a capital offense, when you conspire to commit a capital offense, it's just an F1. So I believe he is entitled to a bond on one. However, count two is a punishable by life offense. So as to count two, state's requesting that you set it at no bond. Stay count three, stay count four, and set a reasonable bond as to count one, as it is an F1.
Okay, and so we'll go ahead and put $100,000 on count one, Count 2 is a 0. Count 3 is 50,000, and count 4 is 20,000. And, all right, and then if he makes bond, he is to have no contact with the victim, co-defendants, and he's not to return to the scene of the incident. He's to be drug-free, and he is to not to possess firearm, ammunition, or weapons. Thank you very much. Next, we have Christina Moore.
Your Honor, she's a refusal.
Refusal, okay.
I will waive, Your Honor.
Okay, we'll go ahead and see, 1 felony, 1 misdemeanor. So selling of meth, we'll leave it as is, and no contact with the victim or co-defendants, no return to the scene, to be drug-free, and to not possess any firearms, firearms, ammunition, or weapons. Next is Laura Moore.
She's also a refusal.
Okay.
I will waive, Your Honor.
Okay. Let's see, we have 12 felonies, 10 misdemeanors, 10 failures to appear, and then unknown 11. So we'll go ahead and change the possession of cocaine to be a $10,000 bond.
Which one, Your Honor? She has 2.
Say again?
Which one?
Okay, there's more than one?
There's a warrant, cocaine and paraphernalia, and then a new law, cocaine.
Okay, let me separate these pieces of paper and see what you're talking about. Okay, I see what you're talking about. Okay, the case I'm looking at is 689, and that's $10,000. The case that is 1036, I guess 40?
Stay the bond, Your Honor. It's a warrant. It's set at 1,000 and 100, being that you already set the other possession at 10,000.
There's no objection to that, Your Honor.
All right, we'll leave it as is on that one. And so, so he's to have, to be no contact, no return, drug-free, no possession of firearms, ammunition, weapons. Okay, next we have David Ortiz. Mr. Ortiz.
How you doing, sir?
You have a felony. This is fleeing and eluding with sirens, etc. And your background, you have 1 felony, 0 misdemeanors.
Your
Yes,
Honor,
ma'am.
he does qualify for a pretrial release. I would ask for a pretrial release, given he only has 1 conviction on his record, which is from 2009. No failures to appear, been in the area for well over a year. So I would ask for pretrial release, given that he does in fact qualify.
State, I see someone standing. Is she standing because of him?
Yes, Your Honor.
Okay, come on into the witness box. All right, ma'am, if you, you can take your mask down to where you can, all right, now speak loud and clear. Tell me your name, spell your last name, and then once you do that, the clerk is going to have to put you under oath to testify truthfully.
Martha Perez, P-E-R-E-Z.
All right, Ms. Perez, be placed under oath.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, what do you want me to know?
Just about my son. He's a good man. He really needs help. He has a drug addiction that we can't get him out of it. And I just came today because I want your help to see if we could get him into a program so that he doesn't get into further trouble.
Well,
I just can't
you know,
afford a program. I just need some assistance. I really need my son. He did die on me twice from this drug and came back. And I don't want the next time to be the end for my son.
Okay, all right, thank you, and I'm sympathetic to you, and
Thank you.
it is sad when your son gets into trouble like this. State your suggested bond amount.
Your Honor, state would ask on the fleeing for 5,000, and that's for you to stay the loitering and prowling at 250. I'm sure you would explain to the witness that we can't put him into rehab at this point or any substance abuse treatment at this point. What would happen is you could contact the state attorney's office, and if these cases are filed on and then they end up in a plea or trial and he was convicted, then that potentially could be a part of the plea. But you'd have to communicate that to the state attorney that's on these cases. I'll give you a card with the case number, but we can't do anything today as to like substance abuse treatment or anything like that. Just so you know, let's say would ask that you set those bonds, Your Honor. And given that he does have a 2009 controlled substance case, I believe it was out of Orange and it was a withhold, potentially to help ease his mother's fears regarding his potential hold on this drug, no drugs or alcohol, and random UA, as Your Honor has done on other cases today.
We only have one case in front of us. Nothing else has been filed yet. So the only thing I have is the fleeing and eluding.
We don't have the loitering and prowling as well?
No, it's not. I don't have paperwork of that. So you might check to see if it needs to be brought tomorrow or something. All right. You know, I don't attach to the warrant the facts, the allegations. So is this attempting? So it's a capious. So, oh, here it is. Okay, pretrial release just gave me what I was looking for. So let me have a moment to read this.
Your Honor, really?
For a second. Almost one.
Loitering and prowling. He's sleeping.
He's left on windows. What are you talking about?
It's supposed to be found to be asleep.
Being on the residence door, well, it was like 11, almost midnight.
Because I didn't have that one either.
Victim opened his residence door, approached, and he was sleeping on the staircase, knocked on the residence was to answer.
I didn't see this. I just saw this. I was wondering.
Went to the upstairs neighbor, and they said, I have no idea who that is. He said he lives there. We couldn't confirm that.
Okay, just want
He did not live in the residence.
I just didn't see them. I just saw this.
And ma'am, I'm gonna give you this card. It has both of his case numbers and the division and the state attorney's phone number, so you can call with any Concerns?
Thank you.
Okay, yeah, this isn't what I, oh, this is loitering and prowling.
Yes,
Um,
it's his other case.
And I was looking for the fleeing and eluding sirens.
Mm-hmm.
That's a warrant.
It's the
So,
warrant case, Your Honor.
Would you?
So as far as the fleeing and eluding, we'll go ahead and do a $10,000 bond. And he is to have no contact with the victim, not to return to the scene of the incident, and he's to be drug-free, and he's to be drug tested 30 days from release, and then random drug testing each month thereafter, and then no firearms, ammunition, or weapons. All right, thank you very much. Thank you, ma'am.
Are you leaving the bond on the loitering charge, Your Honor?
Say again?
Are you leaving the bond on the loitering charge?
Okay, there is a bond, you're saying?
Yes.
And so, what was that bond?
$250.
250?
State has no objection, Your Honor, just with a no return to the Grove Park Apartments, 5317 Curry Ford Road.
Right. Yeah, 53, that's 5317 Curry Ford Road. To that whole complex, he's not allowed to go there at all.
Okay.
I think so.
And so we'll change the bond from 250, you tell me, we'll change it to $1,000.
Your Honor, I would object. I mean, he already has the $10,000 bond on count one. He only has one charge on his record. He has the community ties, no failures to appear. I believe the $10,000 bond is sufficient. The state asked for $5,000. You set it at $10,000. I believe $250 is sufficient on the second charge, Your Honor.
State?
It has no objection to $250, Your Honor.
All right, we'll leave it at 250. Okay, ma'am, thank you very much.
Thank you, sir.
Okay, this is Alexander Patterson. Mr. Patterson, you've arrested for a felony, carrying a concealed firearm. You have one failure to appear, no felonies or misdemeanors, but carrying a firearm is a $20,000 bail, so your bail is $20,000. Failure to have no contact with co-defendants or witnesses, and to be drug-free, and to have no weapons, firearms, or ammunition.
Your Honor, again, I would object to $20,000. My client can afford a $20,000 bond, given he has little to no criminal history other than a possession in 2018. I believe that bond is too high. If we leave it at the bond that was set, the $2,500 and the $500 on his driving while license suspended, he can post that here because he has to go to, I don't know what county that is, Embry County, to deal with that case. If you set it at $20,000, he's going to sit here until this case is resolved, then be transported. So if we allow him to bond out here, he can be transported to that county to deal with whatever case while he's waiting to resolve this case.
All right, thank you very much. Bond stays as is. Say again?
He also has a
He has a
Willis.
second case? Okay, okay, we have the carrying a concealed firearm, which is the $20,000 bond. And then we do have a driving with license suspended or revoked, and $500. We'll leave it as is. Okay, next is Jesus Plazas. All right, and we'll go ahead and enter a plea of not guilty.
Your Honor, I ask that it be reset for tomorrow.
Okay, all right, we'll
Was
call
mental
it
health?
back tomorrow.
Two.
Next is Edward Robinson. Edward Robinson.
Yes, sir.
Mr. Robinson, you're charged with a felony, a failure to report, and state your recommendation on bail.
Your Honor, I believe he has at least one prior conviction for the same thing of failing to comply with the registration. So state would ask for 5,000.
All right.
It also has 2 failures to appear, one that was recent in 2021.
All right, we'll leave it at, we'll make it 5,000. And you are to report as required, not to return to the scene, not to have any contact, no weapons, firearms, ammunition. Okay, I have next Angel Rosario. Angel.
Your Honor, he bonded.
He bonded, okay, thank you. Okay, next is Moses Sanchez. Mr. Sanchez, you have a felony, failure of defendant to appear in court. In state, do you want me just to have that trial court deal with it?
Yes, Your Honor, state would ask that you
We'll
stay the no
just
bond.
leave it as is and let the trial court deal with it. Okay, next we have Alan Spalding. Okay, Mr. Spalding, you're charged with a felony, failure of defendant to appear in court. We'll allow your judge to deal with that, and so we'll leave the bond at 0, and you'll see your judge for that case. Next, we have Taylor. Okay. Okay, Bruce Taylor, you're out on bond, petty theft, 2 priors. We'll go ahead and forfeit the bond, revoke the bond, well, forfeit it. And in that case, you have 4 felonies, 8 misdemeanors, 2 failures to appear, 7 unknown what they are. So we'll change the petty theft, which is a felony because you have 2 priors. We'll change that to $2,500.
And Your Honor, to be clear, that's his out on bond, the 7327.
And that is 327, right? And now, and that's 327. The other one is 063 1. and that's robbery by sudden snatching. We'll go ahead, that's a felony, and we'll go ahead and change that to $5,000. And then he is to have no contact with the victims, no return to the scene, to be drug-free, to not possess any firearms, ammunition, or weapons. All right, thank you very much.
Your Honor, he also has another warrant for a petty theft 2 prior.
Okay.
That's the 10242.
Okay, yes, I just was handed that. Now, this is a petty theft 2 priors. I thought I dealt with that.
He was also out on bond for a petty theft 2 prior. It's 2 different cases.
Okay, okay, all right, we'll change this $1,000 to be, what did I, the other one, was it 25 or 5? I forget what. 5,000. Right, the same one. All right, that's, so the one that is 327, we'll do it 5,000. And there's only one count that I'm aware of.
I'm so confused.
Yes, on the auto bond, there's only one count.
One was 2,500. Just change it.
Okay, I was curious. All right, it's 2,500, sorry.
The out on bond is 2,500. The robbery, sudden snatching is 5,000. And the new warrant, petty theft 2 prior.
10242. The petty theft, okay, you're talking about the petty theft?
Yes, Your Honor.
Oh, okay. All right, all right, the 2 priors. Okay, so this is a new 2 prior petty theft.
Yes.
Okay, all right. And we'll go ahead and do it at the same amount, which is 2,500. Yeah, we'll do it as the same as out of bond.
And state would request a no contact, no return.
Right, no contact, no return, drug-free, no firearms or weapons. Okay. Next, we have Wayne Wetherill. And this is fleeing and attempting to elude 1 time, and then possession of a firearm and the commission of a felony, and then tampering with physical evidence, resisting an officer, open carrying of a firearm. So fleeing or attempting to elude, we'll go ahead and do that at 20,000. And then possession of a firearm and the commission of a felony, we'll go ahead and do that at 50,000.
Your Honor, I would object. That's tantamount to no bond. My client's not going to be able to afford 20,000 on 1 count and 50,000 on the second. If you look at his history, he has no convictions, community ties. He even qualifies for pretrial release. His risk assessment is low. The purpose of bail and bond is to secure one's presence, protect the community, and understanding that a firearm is violent. He has no indication that he is a violence to the community. So I would ask that you consider reducing those bond amounts. If you're going to set one high, the fleeing and attempting to elude, I would just ask that you stay the bonds that are set on the remaining counts at 5,000, 1,000, 150, and 1,000. In this case, Your Honor.
Our state has no objection to that, and believes it's reasonable given his lack of criminal history.
All right, so the fleeing or attempting to elude is 10,000. The possession of a firearm and the commission of a felony is 20,000. And then tampering with physical evidence, we can leave it 1,000. And then resisting the officer, we can leave it at 150. And then open carrying of a weapon or firearm, we'll leave it 1,000 since we've dealt with the seriousness of it. Carrying a gun under any circumstance is threatening to society and to other people. You run into someone else with a gun and there's a gun battle, and why are you carrying a gun if not to threaten society with robbery and all the rest of it. So guns imply violence, and they should be dealt with seriously by the court system, that violence is violence. It's not just a bad cold. Weatherall, okay. Okay, next we have Donald Welch. Donald Welch.
He's present.
Okay, Mr. Welch, you're charged with a felony, failure of defendant to appear. And so here's a capias. So you have a, so we have what, how many cases do we have here?
We have 2 for Mr. Welch, and the state requests that you stay the 1,000 on the failure to appear.
Okay, we can leave, let's see, now, Mr. Welch, you have 13 felonies, 4 misdemeanors, 1 failure to appear, and then there's 2 pages of descriptions. So, failure defendant to appear, we'll change that to be $5,000 because of his prior failure to appear.
And Your Honor, given that it's another judge's KPS, it cannot be changed at IA by another judge who did not issue the KPS, so state would request it to stay at 1,000. And if Your Honor is inclined to change his bond, change it on his leaving the scene as it is a new law.
Okay, all right, we'll leave the KPS at 1,000, and then leaving the scene of a crash with property. That's a traffic offense, so that doesn't make any sense.
It's a misdemeanor, Your Honor.
So it's indicated on here as a traffic, but you're saying it's a misdemeanor? Okay. All right, we'll leave it at 1,000. Next, we have Jesse Williams. Jesse Williams. All right, and what is this? Oh, okay. Oh, so the bond company picked him up and brought him to the jail? Is that what that means? State, do you know what this says? Recommitment to custody. Oh, okay, I think I've not seen this form before. So recommitment to custody, apparently the person who was on the bond picked him up and turned him back into the jail for some reason.
Okay.
Does that
The bond was endorsed, Your Honor.
Doesn't change anything.
So the bondsman just came off the bond and added the charge back onto the defendant, who's in jail currently.
Yeah, right, so when they come off a bond, he just goes back in jail without a bond.
Well, no, it goes back to the bond that it was originally bonded out on. So whatever bond it says on the sheet is the bond that's on it right now. 1,000, should be 1,000.
Okay, so your bond company came off it, so you still have $1,000 bond. Even if the bond company comes off it, I'm not aware of, unless state you're aware of some new offense. Here's some paperwork. Possession of cocaine. Okay, so that is case number 6865. So that would be the new charge, and so the bond company just turned him in. Does that make?
I guess so, Your Honor. I'm not sure.
Okay, all right, so the possession of cocaine, or is this the case that he went on a bond? Let's see, if it describes 865, see if it,
He was arrested 6/13.
865, okay. So the bond, he came off the bond on this case, so this possession of cocaine is not a new case. This is the original one that got a $1,000 bond. He bonded, and then the bond company came off it. So he still has a $1,000 bond, so I don't see, I don't have anything to do. He's got a bond. He just needs to find another person who will go on the bond with him. All right, that's enough.
I don't even have paperwork.
Okay.
I don't know what that was.
Next, we have,
I thought it was here.
Wright. Ms. Wright, you're charged with a felony, possession of cocaine, possession of paraphernalia, possession of cocaine with intent to sell within a school area. And you have 2 felonies, 0 misdemeanors, 1 failure to appear. And so she picked up on a warrant. Yeah, you have there's a warrant. And so the judge that signed that gave you count 1 and count 2. Count 1, 500, count 2, 1,000. So we'll leave those as is. All right. Any more? The clerk tells me that's it. I can see people grabbing their purses.
I am ready to go. I don't believe that's anything else. There's nothing
Okay.
further from the state.
All right, I think we're done. Thank you very much, folks.
Yeah, that works.
Corrections, do we have any interpreter cases? Okay. Okay. Okay, who is your defendant?
Good morning, Your Honor. Jeremiah Allen, my defendant is Mr. Reed, Brett Reed.
Brett, B-R-E-T-T? Brett, okay. Can we call? I see Reed. These are alphabetized, aren't they? Yeah. No, I have Reed. Oh, Brett Reed. Okay, Brett is the first name.
Yes, Your Honor.
Okay, I was, okay, so we'll call Brett Reed.
He has no other history.
Okay. I guess they're still bringing up people from. Okay, can we go ahead and have Brett Reed brought up?
Thanks for the mask.
Good morning, Your Honor. Jeremiah Allen on behalf of Mr. Reed.
Okay, do we have anyone in the audience who is here because of Brett Reed?
Not to my knowledge, Your Honor.
Yes, we have a lady shaking her head. Can she be brought into the witness box, please?
Okay, appreciate that.
Can you press the button, Madam Clerk?
Probably will. Okay, ma'am, if you will tell us what your name is, please, and spell your last name.
My name is Catherine. My last name is Schutz, Schutz.
Okay, you have a soft voice.
Yes.
So can you speak louder, please?
Yes, sir.
And, all right, the clerk will put you under oath.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, now that's nice, loud and clear. Thank you.
You're welcome.
How do you know the defendant?
He's my husband.
All right, and you're going through a divorce now?
We're starting the process soon.
Okay, and how long have you known him?
I've known him for 3 years.
For how long?
3 years. We were
And
married in December.
do you still live together?
No, he threw me out last week.
All right, now, you have, when I was reading the paperwork, you have an injunction against him?
Yes, sir.
All right, and do you have any children together?
No, sir.
All right. In the past, has he been violent towards you?
Yes, sir.
And can you briefly explain?
At the end of July, I was getting ready to go on a beach vacation with my
Can
family.
you speak a little louder, please?
At the end of July, I was getting
You can
ready
pull
to
the microphone down so you don't have to stand on your toes.
At the end of July, I was getting ready to go on a 3-week beach vacation with my own immediate family, and he wanted me to leave a room, the guest bedroom, and I was a few feet away from him, and he was being a little bit controlling and saying he wanted me to leave the room, and I didn't think that I needed to leave the room. So he said, okay, well, then I'm going to make you leave the room. And then he proceeded to grab, he moved me to the floor. He grabbed my left
Okay,
arm.
now, let me ask you, the incident that he's in jail now for, is he called you a couple of times?
Yes, sir. And in breach of the no contact order.
Right. And Is there any alcohol or illegal drugs involved in this relationship?
I don't do any drugs.
Okay, well, what about him?
He uses marijuana, medically marijuana.
Okay. Do you still fear for your protection?
Yes, Your Honor. May I say something?
Yes, ma'am.
He has threatened to kill myself 2 times.
He's failed to what?
Kill myself and his parents 2 times in an aggressive text message on August 21st, I believe. And then also he's been very violent lately at the house and aggressive. I wanted him to seek help. I kept asking when his next therapy appointment was, and I kept getting
Okay, all right.
he kept
And
saying it was
so
moved.
let me ask the attorney, did you put your appearance on the record? I think you did in the beginning. And did you want to ask her any questions?
Was there in this particular, was this on the violation of injunction, are you just saying that there's phone calls that he made to you? Is that the only contact you're alleging, ma'am?
Yes, sir.
Okay. And was there any text message or anything besides those phone calls?
Yes, there was a text message.
Okay, all right. That's all I have, Your Honor.
All right, State, did you have any questions?
No, Your Honor.
All right. Defense attorney, did you want to make a statement?
Yes, Your Honor. I would just say to the court that my client strongly denies these allegations. He denies making these phone calls or having any contact with his soon-to-be ex-wife. He has no prior record. We are set for the formal. It's a temporary injunction that's in right now. We're set for the formal hearing on Monday, and we'll decide all these issues. He's fine with staying away from everybody, and he does have some mental health issues that he'll continue to address. So we'd ask that, I think the public defender said he does qualify for pretrial release. The state and I also, and I would, no problem setting a bond at $5,000 if the court would consider that. He has strong ties to the community if the court wishes to inquire about that.
All right. And so you said 5,000?
Yes, Your Honor.
All right. We'll go ahead and set the bond at 5,000 with no contact, no return, and does he have any weapons, firearms, ammunition?
No, sir.
All right.
Not allowed to.
Right. Okay. So you are prohibited from obtaining any firearms or ammunition or weapons of any sort, and so you have a very fine attorney. He'll represent you very well, and you just need to follow his advice. And otherwise, you're going to be back here, and it'll be much more expensive or difficult to get out of jail. Do you understand me?
Yes, yes.
All right, all right. Okay, anything else, Madam Clerk?
I have
Anything else, State?
No, Your Honor.
All right, thank you very much.
Your Honor, this may be, I'm not sure if this is totally related to this case, but this may be more of a family law issue. I know that they were living in a house in Winter Garden when all this boiled up.
Well, he can, if you're asking for him to be able to come and get his personal items, yes. Ma'am, are you living in the place where the two of you live together?
No, he threw me out and changed the locks on the doors.
Okay, so he has no reason to come to where you're living?
No.
Okay, so who's in that place now? Is that him or someone else?
It's him and his parents.
Him and his parents?
They own the house.
son Thor.
And his son Thor.
All right, at this point, I think we've done everything. Have we covered what you needed?
I believe so, Your Honor. Thank you. I appreciate it.
All right, thank you very much.
Thanks. Have a good day. Good seeing you, Your Honor.
Okay. Okay, Tyrone Thompson.
Mental health, Your Honor.
Okay, mental health, and we'll
Can
go ahead and
we,
reset this.
reset for tomorrow, Your Honor? The reason he wasn't brought yesterday was because we didn't have the sign interpreter. He does have a plea to plead both of his cases out, and we're trying to resolve both so that he's able to go home. So I would just ask that he be reset for tomorrow.
Okay, I'm sorry, here's. Okay, next would be Ashley Brown. Ms. Brown. Okay, Ms. Brown. This is battery, domestic violence by strangulation. You're in jail for a felony. And then let me look at. I see there's a substance abuse history, did have robbery, and so, all right.
Your Honor, she qualifies for pretrial release. Looks like her last conviction was back in 2015 for a driving while license suspended. I would ask for pretrial release in this case.
All right, State.
Your Honor, if you are inclined to put her on PTR, State would ask for bond and PTR, given the allegations within the affidavit. Also with a no contact with the victim, witness, or co-defendant.
Right. I do see the last conviction. So use of possession paraphernalia, a robbery with a firearm. If I misread some of this, correct me, please. So we'll go ahead and set her bond at $2,500 with no contact and no contact, no return, and no firearms. And since she has a history of drug issues, we'll have her drug tested once a month until the case is disposed of. Anything else, State?
Your Honor, you said no contact. Is that with just the victim or witnesses and co-defendants as well?
I'm sorry, with the victim and any witnesses or co-defendants, if any.
All right, thank you.
Thank you.
Your Honor?
Right, no drugs or alcohol and
Your Honor?
drug testing. Yes, ma'am.
They're both, the victim is also arrested. Did you say?
The co-defendant.
Or the co-defendant. Same thing. Is that the person who was arrested?
Co-defendant's also arrested. Which I believe is her wife.
Okay. And you're asking for no contact?
Did you read the affidavit?
The co-defendant? I just want to make sure. Okay. Your Honor, we would ask that she be allowed to have contact with the co-defendant, not the victim. The co-defendant is her wife. So I would ask for contact with her, but not the victim. They're married, Your Honor.
Okay, no, that's fine.
Your Honor, State's concern was the allegations within the affidavit. It was from reading it, a pretty violent attack where they both basically conspired together to do separate things to the victim. So state's just concerned, however, understanding that it's within your discretion.
And there's privilege, Your Honor, there, the victim's not in the home. Again, I would just point out that, how long have you been married?
There's privilege not to testify
15
against each other.
years, Your Honor.
All right. I'll allow contact with the co-defendant because, and put it because they are spouses. And, you know, the state is reasonable in asking for what they, to have a no contact. So the point I want to make is, if I see you again, or if there's a violation, there will be no contact because you'll probably be in different parts of the jail. Do you understand me?
Yes, sir.
All right, thank you very much. All right, Antone Douglas. All right, Mr. Douglas, you're arrested for a felony, battery, domestic violence, criminal mischief, and we do not have anybody, for the record, we don't have anybody in the audience to speak to this matter.
Your Honor, just for the court's awareness, both cases are the same victim, Ms. Pineda. So state would just ask that you take that into account when setting his bond. I believe one incident was August 5th, and the other incident was August 10th, both with the same victim.
All right. I do see here, okay, here's an arrest warrant. So he was picked up on the warrant?
Yes, Your Honor.
Okay,
On
so
both.
the judge in that case said count 2, which is the criminal mischief. That judge set it at $1,000, so we'll leave that as is. And then count 1, the domestic violence. What does the state suggest for that?
He does have a little bit of history, Your Honor, including a prior conviction for an ag bat. The state would ask for $1,000.
All right. We'll go ahead and do $1,000 on count 1. And okay, and then no contact, no return, no weapons, no drugs. Let me look here. No particular drug history, so well, let me look next page. I tell you, when I look at that second page, he has a lot of history. False imprisonment, cruelty, aggravated battery, probation violation.
Your Honor, I would just point to the fact that on that, those are arrests. He was never convicted of those charges, Your Honor.
Okay. Does the state want to address her point? The defense lawyer's point?
I mean, yes, Your Honor, there are arrests. However, there's also a fairly lengthy conviction history as well, both in-state and out-of-state.
All right. We'll go ahead and because of his history, we'll change it to $10,000. And so $10,000 with all the other conditions.
I would object to $10,000 on the second battery, Your Honor. His last conviction, it looks like, was in 2016 for a trespass.
Okay, before that?
All of these, again, I will point to the fact that he was not convicted of these charges. Even out of state, his last conviction was a driving while license suspended. I just don't think it rises to the level of a $10,000 bond. Would you at least consider reducing that to $5,000, Your Honor? since we already have the other two set at 1,000.
All right, we'll do a 5,000 then for that first count. And so,
With the same conditions, Your Honor?
and then, yes, okay, I see. Yes, same conditions, and the state's information and belief essentially the same?
I'm sorry?
Okay, so we'll do 5,000 there. Yes.
So to be clear, that was, Madam Clerk, that was 5,000 on one case and then 1,000 and 1,000 on the other?
No, no, no.
No?
No?
No, 5,000, 1,000, and then 5,000. So on the
Can you bring him back?
case that is 5423.
So 5,000 on each of the batteries and then 1,000 on the criminal mischief?
Yes.
Okay.
Your Honor, I'm confused. So when we're bringing the defendant back, because when you ask the state asks for 1,000, which you granted on one of the batteries, and then you wanted to set the second battery at 10,000, and I asked for 5,000.
Right.
And then the judge set the criminal mischief at 1,000.
No, the criminal mischief stays the same.
Right. But
Yeah,
the
that,
state asked on the second, on the battery for 1,000, which you granted the $1,000 bond, correct? Yes.
no,
So then I asked for you wanted to set the second battery at 10,000, and I asked for 5,000, arguing his last conviction was a
you were
trespass.
talking about the second case?
Your Honor, I believe what he said is reasonable. I mean, he had a 2022 BAT DV, same victim from June, ag bat, false imprisonment, child abuse, tampering with a witness. 2022 from May, same victim.
Okay.
2017, BAT DV, 2016, BAT DV, 2016, BAT DV. It's
Okay.
an ongoing thing. So, Your Honor, what you said, I believe, is reasonable.
So
which is
the
11,000 total.
So the prior judge did the 1,000, I did the 5, and then on the second case, I did the 5 also.
Okay. It's
So-
fine, Your Honor.
Yeah,
It's fine.
okay.
It's fine.
Okay, next should be Charles Fort, Mr. Fort. All right. Mr. Fort, you're out on surety bond, and I do revoke the prior bond. I set apparently there's a felony and a misdemeanor, there's 2 bonds. So the felony, I'll go ahead and change that to be 10,000. And then what was 500, we'll change that to be 1,000 as far as that case goes. Then,
Your Honor, is that the out-on bond?
I'm so confused.
Your Honor, state would ask that you revoke and set it at none. He bonded on that case on August 11th. He picked up this new case August 23rd. It is the same victim and the exact same charges. So state believes since they are the exact same charges and the same victim in a short period of time.
it's the same victim?
Yes. So state would ask that you revoke and set it at none on his out-on bond.
Well, you know, the appellate court says we should seldom, if ever, do no bond, no bond, except the ones that are, the law allows. And so that's really not anything I can do there.
Your Honor, it is a legal sentence, and the PD would then file a motion to set bond on that case, which the victim would then have a right to be heard. The victim is not here to be heard.
And Your Honor, I would ask that you stay the bond you set. It did not occur August 23rd. From what I am seeing, it started July 27th. And this was a warrant that was signed. So originally on the out-on bond, it looks like it was July 27th that this occurred. And then for some reason, it's showing July 27th on the new case as well. So again, Your Honor, I would ask that you stay the bond that you set. I do not see an extensive criminal history here, so I just ask that you stay the bond you already set.
21.
Okay, clarify for me, is the new violation predating the other bond or postdating it?
The new law, she was ongoing in divorce. She had charges filed 7/27, which is the previous case. Additional charges were filed for him. On 8/21, she once noticed he was texting her and photographs from a number. And then on 8/23, he was getting more phone calls from him, which would be predating the other case where the date of incident was 7/27, the arrest was 8/9, and the bond was 8/11. So yes, it does predate it.
And Your Honor, one more thing, the state has not filed on any of those charges, even though he was arrested back in July.
Well,
He was arrested in August.
okay, we'll go ahead and revoke the bonds and do what I've already said, which was 10 and then 1,000. And then on the, so that takes care of that one. And then on the new, okay, thank you. So then we have a violation of domestic violence injunction, once, twice, it's up to felonies. So we'll go ahead and do the no contact, no return, no drugs, no firearms or ammunition. And as far as the bond amount, State, can you help me on what is the other violation? This
New violation?
Yeah. When I read it, I'm a little. Can you point out the
There
issue?
is a no contact in place due to the injunction. She began receiving text messages and photographs from the number, which was previously used in the other incident. Photographs were personal and only Charlie and she would have access to the photographs. Correspondence through text message. Received a call to her desk phone from a subject who referred to himself as Tony, who she recognized the voice to be the defendant. She told him that he's not allowed to contact her. She ended the call. He attempted to call her again that next morning. So multiple phone calls and text messages.
Well, you know, that's violation of the original injunction.
Yes.
And so what does it take to get you to leave this person alone and not contact them in any way and let the legal process go forward? What does it take? Yeah, go ahead and speak if you want.
Your Honor, I'm in the process of filing a divorce myself. I have an attorney, Michelle. She's not here today because she has death in the family, so I have to set up a public defender. And my contact is not with her, Your Honor.
All right. Well, let me address one thing you said. The public defender is here every day. They're very schooled and they do a good job in criminal law. So there's been no loss of representation because you're divorce lawyer who may also do criminal. But the public defenders, especially in this court, are very experienced and good people. But, all right, so what do we do in the other one? Yes. And for him. Right. So we'll go ahead and so there's one, let's see, violation, aggravated stalking. Let me ask State, what is the aggravation of the stalking?
Your Honor, I believe the aggravated factor is because there was an injunction in place. Knowingly, willfully, maliciously, repeatedly followed, harassed, or cyber stalks her when there is a court-imposed prohibition of contact in place.
It's the contacts, the constant contacts?
Yes, since there is already an injunction.
All right, so you see you're in jail now.
Sir.
And so if you keep contacting this person, you're going to wind up in prison in the sense that domestic cases, people do things out of, oh my God, you know, they do things just out of temper. And I've had 2 women murdered in my judicial career by the husband, I forget who the persons were. But this kind of contacting in a domestic relations situation is extremely dangerous for the victim, and you could wind up going to prison. And so the point I want to make is this got to stop. And so that's really the issue is how do we protect everybody and not have this get worse? And so you wanted to say one thing briefly?
Yes, sir, Your Honor. I reported the incident. She was trying to contact me. I have a card from Orlando Police Department, and they just told me, don't answer your phone or anything. So I asked for guidance, you know, she's trying to contact me, so I'm trying to get away from it.
Well, you need to block her number.
That's what I did, Your Honor.
Okay. We'll go ahead and do the violation of the injunction will be $5,000, and then the aggravated stalking, since it's mostly just phone calls and stupid stuff like that, we'll go ahead and do that at $2,500 with the no contact, no return to wherever the incident may have occurred, and no weapons, no ammunition, and all right, State, anything else?
No, Your Honor.
All right. Okay, next we should have Shamiria Franklin Brown.
Thank you.
Okay, and you are not out on bond that I'm aware of, and so you've been arrested for felonies, a robbery, sudden snatching, and then battery, domestic violence. State your suggestion.
Your Honor, this is the co-defendant to one of the earlier cases. I believe in that case on the battery by strangulation, you set it at $2,500. with the standard conditions of no contact with victims or witness, no return, no weapons, and no drugs or alcohol.
All right, we'll do the same thing here. So we'll just duplicate it.
However, Ms. Franklin Brown does have 2 charges. The previous defendant only had 1.
And Your Honor, I would ask for a $500 bond on count 2, given that she took the phone out of the victim's hand. So I just ask that you consider those facts. She has no failures to appear. Last charge was back in 2012. So I just ask that you treat the second count, I guess, as a subsidiary.
State your suggestion.
Your Honor, state has no objection to 2,500 on 1 and 500 on 2.
All right, we'll go ahead and accept that. With the same conditions, Madam Clerk, yes, we put what, no contact? What was?
No contact with victim or witness, no return, no weapons, firearms or ammunition, and no drugs or alcohol.
Okay, thank you. Next is Alan Johnson. Mr. Johnson. Okay. You've been arrested for felonies, aggravated battery with on a person over 65.
Sir, may I get a chance to explain? Sir.
Stop. Wait a second.
That's aggravated battery, then a battery, domestic battery by strangulation.
Sir, my mother.
Can I have a moment, Your Honor?
Yes.
Sir, my mother.
Okay, talk to your lawyer for just a second.
In Your Honor, just regards to PC, I believe there's potentially some scrivener's errors by the deputy. Count 1 should just be an ag bat on a person 65, not with a motor vehicle. And count 3 should just be a tampering with a witness, but not in a life or capital proceeding.
All right. And then robbery was just involved in that same incident?
It's all in the same incident, Your Honor.
Right, all the same. All right, your suggestion as far, let's go down the counts. Count 1, aggravated battery on a person over 65, your suggestion? But we do want to always look at someone's history. So Alan Johnson, when I turn the page, there isn't much history. I do have some concern from his appearance just now of mental health, emotional stability, but that's just a note.
Actually, Your Honor, if you look at page 2 of the sheet we received from pretrial services, it does confirm the mental health.
The aggravated battery on a person over 65, without any criminal history to speak of.
Your Honor, state's concern is there was a prior battery on a person 65 or older and bat DV with the same victim, his mother, Ms. Johnson. That was in early 2022, it looks like, or December of 2021, so approximately 9 months ago. And I believe Mr. Johnson currently has an open non-arrest bat Leo. And that's just coupled with the potential mental health issues, state's concern regarding the victim's safety, given that they do live together and that she is over the age of 65. I believe she is 76. So given that it is not an isolated incident, it seems to be potentially an incident that has at least occurred once before. State would just ask that you take that into account when setting his bonds.
And, Your Honor, I'll just point out the fact that no charges, or they did not move forward on any charges. The only conviction I see was in 2004 for the last conviction, should I say, is trespass and resisting without violence. And those are, all the charges. They're resisting, petty thefts, and trespass. As well as the fact, Your Honor, that the no contact order is gonna suffice in preventing any further altercations with his mother, as well as
Your Honor,
if you look.
Your Honor, one thing, I love my mother, and this thing is wrong. My mother lost all her mental pills, all her mental pills. She had no sleeping pills. I was restraining her first, Your Honor. That's what happened. I love my mom. I know I'm right and wrong. I was restraining her. I did not physically harm her. I restrained her. She could not sleep. Me and her could not sleep for days. I was up for nights, sleep every night. I said that morning that happened when the officers came in for me. The morning, the more officers, sir. Last, I'm gonna calm down. I'm gonna stop.
All right. The public defender, I do appoint the public defender, if I failed to say that earlier, for all these defendants. You know, if there's a issue with your mother because of age or not being in good condition or mental health or whatever, you seem like a person who's trying to be compassionate for their mother, right?
Yes.
Oh, okay. You need to make sure that the public defender's office has a lot of services, and they may need to reach out to help the mother, because we are going to want you to not live there anymore, because I'm afraid it could, by accident, occur to where you're having something could happen. And so, but we don't want your mother to be not getting any services. So the public defender should, I think, as an aspect of settling this case, should reach out to whatever government services are available to help your mother. But that's a side issue. We'll go ahead and on aggravated battery on his, we'll go ahead and put that at $2,500. Battery by strangulation, we'll put that at $1,000. And then tampering with a witness, we'll do that at $500. And then the robbery, looking at the context, it really doesn't look like a robbery. Do you have a feeling about whether this was a robbery or whether this is simply part of the domestic problem?
Your Honor, it was, according to the affidavit, allegedly he became irate and attacked her. He used force and grabbed her phone from her hands, punched her in the face several times, causing an abrasion to her lip and causing her teeth to break and fall out. He then strangled her by grabbing her neck with his hands, and her breathing was heavily restricted, and to the point where she thought she was going to die. He then laid her down and put a pillow over her face to stop her from breathing. So she was unable to call 911. So the robbery is taking the phone from her while battering her, so she could not call for help.
All right.
She was a helpless victim.
It is part of the battery.
Okay, so we'll go ahead and do $1,000 there, and false imprisonment would do $1,000. And then no contact with his mother, no return except to get his personal items and use the use of a sheriff. So to get your clothing, your personal items, and then you have to go live somewhere else, you need to call the sheriff and they will go with you. If you have any concerns about your mother, you call the sheriff or you call somebody, but don't go there because something bad may happen. And so, no alcohol, no drugs, but just the no drugs. Okay, State, is there any other conditions you're interested in?
No, Your Honor.
All right, I will give this paperwork to the clerk, and
So
we're,
you're calling PC for aggravated battery on a person 65 or older?
yes,
Separate with the witness.
yes. Okay, next we have Kelvin, Kelvin Roundtree. Mr. Roundtree? Okay, Mr. Roundtree, you are arrested for a felony, written threats to kill or to do bodily harm. And then when I look at your history, total for felonies says 6, but it doesn't have any details.
Your Honor, this state has already filed information, and this is a capias. It's failure to appear, so state would ask that you just stay it. He's already been seen at IA on this case, it's just a capias.
Okay, okay, I see there's a bond.
Yes.
So we'll just
Yeah, the
stay
bond.
stay the bond and any conditions. But we need to wait for the clerk.
No, Your Honor, it's just a
Are
capias.
you okay? We're good? Oh, we're gonna stay the bond.
And that's it.
Yes. Okay, next, next we will have Jody Lynn LeBrer. Okay. Let me, you are arrested for a misdemeanor, a battery. When I look, I don't see any history. Have you been arrested before?
No, sir.
Okay,
Never been in trouble.
okay. Any reason she doesn't qualify for pretrial release?
Your Honor, she does qualify, and state has no objection.
She does, okay. All right, we'll go ahead and release her on pretrial release since she qualifies. And then the domestic, the other the other person in this, what was the relationship again?
Her husband, I believe.
I couldn't understand you.
Her husband?
Oh, her husband, okay. All right, since he's not here to give us information, you will have to have no contact, no return except to get your personal items through the use of a sheriff's deputy. And, ma'am?
Can we do a maintain separate residence, and also the one-time return? He packed up and left the residence, so as long as she goes with the police.
Yes,
he's not.
if he's, right, if he is not residing at the residence, there's no reason for you not to return. So I totally understand that. So that makes sense. If he's not there, you can be there, because all we want is not to be together while things are upset. And so, so we'll strike the no return. But let's put it this way, no return if he is still residing there. So if he's comes, that creates a real problem. If he just shows up on the doorstep and says, I want to come in, I live here, how do we handle that?
Your Honor, that's why I believe defense asked for separate residences. So since if there was a separate residences and a one-time return with law enforcement, she would go back with law enforcement. If he's not there, she can stay. If he is there, she would have to leave. And if she's
Right.
there and then eventually he comes back, she's still under that jurisdiction of the court for separate residences. So if he comes back, even if you're there for a week, she would then have to leave it.
Okay, all right.
So separate residences and a one-time return, I think, is the best way to put it on the record for law enforcement to be sure that she's compliant. with.
Right, so, okay, they live in separate residence, but if he's not in the place, the home, you can live there. But if he comes and wants to assert his right to be there, then you're gonna have to vacate, and call your lawyer right away. And then you do have the right, to take your personal items, with you if you have to move. But hopefully he's gone, hopefully. Okay. I don't remember. I don't think I said a bond on this, did I?
It was PTR, Your Honor.
I'm sorry, what? Oh, that's right. Okay, good. Okay, did we cover everything?
Yes, Judge.
Okay, thank you very much.
And no contact.
Right, if she has to vacate. Okay, next we have Elias Ortiz. Mr. Ortiz, you are arrested for a misdemeanor violation of pretrial release condition on domestic violence, in a domestic violence case. So, in the prior case, there's only one count that I see. State, in that prior case, do you have a recommendation for a bond?
On the violation, Your Honor?
Yes. No, not on the violation, but on the underlying. He was released, pretrial release, on a DV case. So in that case, I need to revoke pretrial release, but I want to give him a bond. So can you help me figure out a reasonable bond for that?
It's my understanding that PTR would already be revoked, and that'd be as PTR would give you that paperwork to revoke it. If they're not giving that paperwork now.
No, Your Honor, he currently doesn't have a FAT for the underlying offense. That's what was the reason for the warrant for that case. This warrant came so we won't have to place a FAT for that case.
So he only needs to be seen on the violation.
So he has a violation, but does he need a bond for that, whatever the underlying issue is? No?
Mm-mm. That's already been handled by this warrant.
But it was handled with pretrial release, but it's no longer, there's no longer pretrial release. So does that go back to the judge that has the case, or does it come to us? Am I asking the right question or not? I'm trying to say, what bonds do I need to do today?
Set a bond or leave it at no bond, Your Honor. I believe that's the way it works, right?
Well, we don't, we're not even touching the underlying. We're only touching the violation. And he's not set at like no bond or anything on the previous BAT DV.
Okay,
So
I don't need to.
It's pretty much like a no action at this point, to my knowledge.
All he needs to do is address
And
the
we're only
violation.
addressing the violation.
Okay,
We're not messing with whatever's underlying.
all right. That was my question, is if we needed to do something. All right, and looking at the violation, state your recommendation.
Your Honor, I believe the underlying BAT DV occurred August 30th, where a no contact order was put in place on September 2nd. I believe the violations are just multiple phone calls, allegedly, to the victim. I believe Mr. Ortiz doesn't really have much other criminal history.
Right.
So state would just ask for $5,000 with the understanding that if he violates again, he'd be sitting here at no bond.
Okay, did you understand our conversation that if you violate, if you make any kind of contact with this other person, that then you could be in jail for a lot more money to get out of jail? And so, did you say 1,000?
I said 5, Your Honor.
5,000? Defense, your
Your Honor, given that he has, looks like only the battery, he can't afford the $5,000. He can afford a $1,000 bond, would you?
all right. Since he has no history, but you know the thing that always, you can't lead your life in fear, but most murderers have no history. That's the thing, we always talk about looking at history, which I do. I think it's very important. But almost all the murders that I've ever done, I did 5 murder trials, and none of them had any history. And so it's always just comes out of the woodwork. Anyway, so the point is, I want you to stay away from this other person. Let your attorney handle it. You need to move on. Do you understand what I'm saying?
Yes, sir.
So I will, because there's no history, but this is a second situation, it better be the last situation. Do you understand me?
Yes, sir.
All right, so I will agree with your attorney, $1,000, but this will be the last time it's $1,000. All right, thank you very much. The conditions are no contact, no return, no drugs, no weapons or ammunition, and anything else?
No, Your Honor.
All right, thank you very much. Next, we have Jonathan Pelham. Mr. Pelham, you are arrested for a misdemeanor. Is a battery, touching or striking another person. And when we look at your history, okay, you've been to prison already?
Yes, Your Honor.
Okay.
I haven't had any trouble since my prison.
When were you released?
I was released in 2015, sir.
16?
15, sir.
15, okay. Oh, I see, March 5 of 15?
Yes, sir.
Okay. And you were there for a drug case?
Yes, sir.
All right. And
I've been out of trouble ever since I got out of prison, and the only trouble I've had was currently now, and then with my relationship with my lady. And that's the only trouble I've had since I've been out of prison. And I want to keep it that way. I don't look forward to coming in the courts because this is not what I.
okay, all right.
Your Honor, when setting his bonds, it would just bring your attention, he did have a 2021 felony battery, false imprisonment with the same victim, Ms. Amarante. However, she declined to prosecute. That was in 2021. So another felony battery case with the same victim. So they would ask that you take that into account when setting his bond. He also had at least 4 prior other BAT DV arrests. It appears out of Polk. 2009, 2010, 2011, 2010, 2011, and then some drug history.
All right, since he's been released, is this the first documented problem?
No, Your Honor, the 2021 felony battery case with the same victim.
Same victim? Hmm.
That's right. That's what I was explaining to you. Those two issues.
Well, is this victim worth going back to prison?
No, sir. I'm done with her, sir. Please give me a chance, and you'll never see me again.
True. There's, all right. The, all right, so we'll go ahead and do this is charged as a misdemeanor. So we'll go ahead and do it as a $1,000 bond with no contact. No contact means no contact. Do you understand? No way, shape, or form. Otherwise, you're going to wind up back in prison. And so no contact, no return to the premises. You must live separate. You can have a one-time return to get your personal items, if there's any there, with a sheriff's deputy only. Live separate. I do, because you have history of drugs, I do want you drug tested each month until the case is, okay, I want you clean. I want you staying away from this person. I want you moving on with your life. No person is worth going to prison again. And so, so you need to just put that on the mirror when you're brushing your teeth. No person worth going to prison. And so State, did I forget anything?
Your Honor, DCF was also contacted, so state would ask for the condition to comply with DCF if an investigation is opened.
All right, DCF, that implies a child together with this lady?
There was a
Yep.
4-month-old that was present, Your Honor.
Okay, no contact with the child until further court order. So, so there's no reason to contact the lady. If you want contact with the child, you have to go through your attorney. And so, comply with any DCF requirements. All right, unless,
Your Honor,
yes,
my client would like pretrial release. Since you're already giving him the drug testing randomly through pretrial services, it's similar to probation. He'll be monitored while he's out. If he violates, he'll be brought back here, held at no bond, Your Honor. So I would ask for pretrial release. Although he has those charges, he has no failures to appear, which is an indication he will, in fact, return for court. So I would ask for pretrial release since he does, in fact, qualify.
well, I would be surprised if he did. Does he qualify for pretrial release?
Yes, Your Honor, he does.
He does?
And
Even having been to prison?
It was at the discretion of the person who interviewed him. If you feel like you don't want to put him on pretrial release, Your Honor, you don't have to. But the person who interviewed him, at their discretion, they qualify him for PTR, yes.
Well, I guess the point that the state was making a moment ago, that this is the same person, a second domestic violence incident that was reported to the police. State agree? Is that what you told me?
Yes, Your Honor, I just wanted it within your determination to consider when setting his bond. However, state has no objection to PTR.
I just think pretrial will give him more supervision, Your Honor, as opposed to just posting a bond. He has no one monitoring him.
Well, no, I just don't feel that that's the safest thing to do. So I'll leave it as is. So thank you very much. Okay, next. Next, we have Sean Stindell. All right, Mr. Stindell, you're arrested for a misdemeanor, battery, domestic violence, and when no reports of drugs, no mental health.
Your Honor, he does qualify for PTR. State has no objection with normal conditions.
Okay. So he can be released from pretrial release with the normal conditions of no contact, no return, live separate, no drugs, and no weapon, firearms, ammunition type thing. And he can return to a one-time return with law enforcement to get his personal items, and then just stay away from that person. All right, and did I forget anything?
No, Your Honor.
All right, thank you very much. We bypassed, let's see. Okay, I think the next one is Kaysen.
Yes. Yes.
All right. Mr. Kaysen, you arrested for a out-of-county warrant. Okay. All right. So you have from a $31,000 bond from Alachua County. We will notify Alachua, and they will transport you or otherwise let us know what they intend to do. So we'll send you back to there if they will transport you. Is there any new offense here?
No, Your Honor.
Okay, all right. Just an out-of-state, out-of-county warrant.
Yes.
Okay, next we have Mr. Paul. Mr. Paul?
No.
Okay, Mr. Paul, you're out on bond for an aggravated battery, great bodily harm.
Your Honor, state would request no action on that, as we do not know the offense date for the out-of-county warrant. We only get the teletype. We don't know the offense date, so we don't know if he was out on bond on our case when that case occurred. So state would request no action on his out on bond Orange County case.
Okay, all right, we'll take no action, but we will notify. So this is out-of-county warrant. It's a zero bond. It's Seminole County. They will be informed if they want to take any action. And does he have a current charge with us?
Yes, Your Honor. His out on bond is currently with us. That AgBat.
Okay, warrant is confirmed. We will pick him up $2,500. Okay, but I'm sorry. Does he have an Orange County case?
Yes, Your Honor. That's what state requested no action on, because we don't know when this occurred in relation to that.
Right, so we would take no action, but there's no new case for us.
No, nothing new, just that out on bond.
Okay, I'm sorry, Okay, next is Devontae Stallings. Mr. Stallings, this is a violation of probation, and we will let and also VOP carrying a concealed firearm. There's a surety bond, so we'll go ahead and revoke.
Your Honor, again, the two Orange County cases, the 2020 CF 11728 and the 21 CF 7965, state would request no action, because again, we don't know when these occurred in relation to that out-of-county warrant. So state would request no action on these Orange County cases and to only address the out-of-county warrant and whatever bond that county set.
Okay, all right. So here's out-of-county warrant, so I'll just hand that to you, Madam Clerk.
So, your bond?
No bond.
So you're taking no action, correct?
Right.
Okay. So Volusia will come get you.
Okay, next should be Sean Goodwin, Mr. Goodwin. Outside medical. So we'll go ahead and let's recall this when he's returned to the jail.
Are you waiving?
I will waive, Your Honor.
Okay.
To VOP, so at no bond, so I will waive so that he's able to
Okay.
move forward.
All right, we'll go ahead and send this to VOP court and let them, he might be back with us by the time they call him. So this is Mr. Goodwin. Okay, next is Philip Jenkins, Mr. Jenkins. All right, Mr. Jenkins, you're arrested for a felony, a violation of probation. We'll notify, it's a no bond situation, and we will send you to the VOP court to determine whether you violated probation or not. Thank you very much. Next we have uh, how do you say your first name?
Jai?
Ja?
Jai.
Judd.
Jai, like Jai. Jai Salarkram?
Jai?
Yes, sir.
Oh, Jai. So the I is emphasized. So Jai?
Yes, sir.
Okay. Jai Salakaram?
Well, it's misspelled. My birth certificate, it's supposed to be Jai Salikram, Salikram. It's Indian descent. I I've had to do this all life. It's always been misspelled.
Okay. All right. You've been arrested for a felony, a violation of drug probation, so it's a VOP, and we'll send you to VOP court, and they can, actually, I enjoyed the VOP court. I did VOPs in this county for a year, and I liked it because everybody's guilty. It's just a matter of what do we do about it, and I think in a way, I tried not to send people to prison. And
I'm trying to get into a rehab. I called my probation officer just after everything happened, and I asked her about the rehab, but I had already
Stop.
Okay.
You know, she just she wasn't in the same ball game as me. She told me don't leave the county,
Well,
so it took it.
but we have the public defender's office, which is an excellent office, and they may be able to understand the facts, circumstances, and to have you. So it's usually, let's say you die, you go back to prison, you go to prison, you get clean again. One of those choices you have to make. It's only you. I can't make you survive. I can't make you clean. Only you in your head can do it.
I've never tried rehab, but
All right. Well, good luck.
Thank you, guys.
Next, we have Victor Williams. Mr. Williams. And you've been arrested for a felony, a VOP, and we will notify the VOP court. Do we have any new charges?
Yes.
Yes, all right, I thought so with a stack of papers. All right, so VOP court, and then you have a driving issue, it looks like, no valid driver's license. Okay, State, how do you want to address this?
Your Honor, State would just ask that you stay the bond with no conditions other than to appoint the PD.
All right, we'll just stay the bond, take no action, really. Okay, all right, Madam Clerk. Okay, now we're going to do the, what is it, 33-day. So the first 33-day, Williams, the last three are 464.
Denied and information was filed.
Supreme, last three are 429.
Denied and information was filed.
Melendez, the last three are 452.
Denied and information was filed.
Diaz, 435.
Denied and information was filed.
Diaz, 461.
Granted, notice and on filing.
Lemon or Lemon, 332.
Granted, notice and on filing.
Well, okay, I guess also known as a name I cannot pronounce.
22 CF 9449, Mr.
Yes.
Osvaldo, denied and information was filed.
And then Owens, 509.
Granted, notice of non-filing.
All right, that's the last one. Okay, now, let's see, it's 10:30. Let me ask, how does the group want to handle the second session? How long do you want for a break so you can do whatever you need to do, if you need to eat? So I'm totally flexible. I'll do whatever you all, and the clerk has to agree.
Can we handle noon? Can we do noon?
Noon?
1:30? Is that okay with corrections?
Dale, does that work with you, for you? To do the second session at noon? Does that work for everybody? I don't want to cause problems for anybody. Can we do second session at noon?
Yes, Your Honor, I think corrections stated.
Everybody in agreement?
Yes, Your Honor.
Okay, all right, we'll see you all at 12.
Yeah, sometimes she's not in there. When I go up there, she won't be there.
Some type of appointment today.
Mm-hmm. Usually when I'm like walking around, I need to get her number, so I just call her. No, she's in my, I mean, her cell phone, because sometimes she's not upstairs.
It's her extension, and that's her cell phone.
Oh, her cell phone. So people always ask me for it. Okay. Yeah, because sometimes I need to get her and I can't. She might be in the appointment. She might still be at the appointment.
Oh, that's true, huh?
I'll text her too.
Okay. Catherine, yeah, they gonna start back at 12. Whenever you come, I'm gonna start putting people.
Do you want to bring down there more for me to sign? I've already, yeah, I did. Okay, there wasn't anything else.
Oh, no, this
That's
was
what I
down
was
there.
wondering. All right, I will be down there.